Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Dati mihi Anglican praise service.
That's literally not correct.
Is that correct?
Oh, for crumb's sake.
Good morning. Welcome to the Court of Public Opinion. Look at the sun shining outside the studio. I'm the Recovery Addict. I missed that part. Welcome. It is beautiful outside. You know what? You know what makes today really beautiful? It's garbage day. And the garbage man came today and dumped our garbage. But normally that would just be like, why does that make it beautiful? Well, because we missed it last week. We forgot to take the cans out last week. And we remembered this week. So finally, the garbage cans are empty. It was becoming urgent. I always loved garbage day ever since I was a kid. I always watched the trucks. When I was a kid, there were people that would like come by and like lug it up into the truck and empty the can for you. Now it's a robot, pretty much. The robot dumps the garbage. Oh yeah. All right. Welcome. Good to have you all here. I can tell you we're going to go to a court we haven't watched a lot of, but we do like. And I'll let you guess the name, but this is a standing judge. A standing judge. I mean, he stands. So you guys can guess who it is. We're going to go there in just a minute as we get set. But first of all, we have to do a couple things first. And look at this. Kayla Newell says, Hi, Kayla. How are you doing today? Happy day. Happy morning. Good to have you here. Unfortunately, you were here first. Unfortunate for you. Fortunate for the rest of us. We're going to punish you for your exuberance. Clearly, you're too excited to be on the internet this morning. Because of that, we're sentencing you to internet ownership, and you're responsible for maintaining everything IP-related worldwide. And on top of that, Kayla.
Mike. What day is it, Mike? Guess what today is?
It's Hump Day.
Hump Day! Welcome to Wednesday. I should have warmed up. Anyway, in other news, 2 thumbs down. 2 thumbs down. I should have warmed up. Maybe if I had sung Happy Birthday first. 1 out of 10, says Tisha. That was weak. I choked on that one. I just choked. No do-overs. No, I don't think I got it in me. Oh, it's wonderful to be here. I promise to do it again next week. Josh gives me a 0.5, which is my lowest score ever. Probably also the most accurate of the morning. Worst one yet. Alright, needs a mulligan. I'm going to try one more time. The only other time I've done a redo on the Hump Day cheer is like the hotel incident when we had the fire alarm. Nothing gets a good Hump Day cheer going like Deer Park water. Not what they advertise, but I think it'll work. I don't know. We have to do the full setup. I'll get the decibel meter going here. Decibel meter. Testing. Okay, test. How do you reset? Oh, it just resets on its own. Okay. All right.
Mike. What day is it, Mike? Guess what today is?
It's Hump Day.
Hump Day! Welcome to Wednesday. 92 on the hump day. You got 2 thumbs up. Oh, 6 thumbs up. All 3 kids came in, gave me the thumbs up. Wow, it's hump day, and I went with the higher pitch. I think it carries better. All right. Okay. Let's see. Is there something going on with Karen Reed today? She is fighting to not go to court. Is what she wants. Of course, she'd like this whole thing to be over, and understandably so. We have some birthdays to sing to first, and yes, the first hump day was weak. That's not the way to celebrate midweek. Dodie. Oh, Dodie. I'm sorry to hear that. Thoughts and prayers for you for sure. Not the news you wanted today. Lindsay says, why do I want to yell back, ollie ollie oxen free? Because you grew up in an awesome time period. That's why. Dodie, thoughts and prayers. You're going to see quite a few messages in chat for you here as well. We're going to go ahead and sing with the birthday stuff. I think there's Hadley. She got added onto it. Wonderful. Thank you very much, Sharon. We're going to do the birthday song very quickly before court begins, which is going to happen any minute now. I just need to find where the birthday song is. There it is. All right. It's time to sing. We need to stand up, take a deep breath, project your voice to the back room, blend your voice with the neighbors, warm up with me, if you will. La 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 la. Excellent, Jennifer. Thank you for leading us in that. All right, we're going to sing happy birthday to Dia, Hadley, and Carolyn Lower, all celebrating their birthday today. Happy birthday to you. Happy birthday to you. Happy birthday, Dia, Hadley, Carolyn Lower, and Catherine. Happy birthday to you. Selena, happy birthday to your granddaughter. Let's see, who did we just add here? Catherine, thank you. Happy birthday to you as well. Dia, Hadley, Carolyn, happy birthday. This is your special day. Of all the days, this one's yours. And I recommend celebrating by getting free stack of pancakes at Denny's, IHOP, Village Inn, Andy's Grill, maybe even McDonald's, wherever you can get them. And maybe all the places if you're that ambitious, because calories don't count on your birthday. So that's good to know. I realize there are a million places you could be, a million people you could have celebrated with, but you've chosen to be here with us. A free cookie at Crumble too. We have to add that. Not a sponsor, but Crumble. I've had their cookies. I can't say the calories don't count at Crumble. I just can't say that. But, Tammy's house, free stack of pancakes if you're at Tammy's house. There you go. Late birthday to Katie. Happy birthday to you. Happy birthday to you. Happy birthday, dear Kathy or Katie, one of the two. Happy birthday to you. Wow. Two of either Caddy or Kathy or Katie. I probably pronounced all of them. But happy birthday. Consider yourself sung to and celebrate the same way with free pancakes at Denny's, Waffle House, Village Inn. Get your free Crumble cookie as well. Selena K, time flies when you're having fun. 19 months. Congratulations to you as well, Selena. Also, not a birthday, but a good celebration as well. 19 months. OG. Calories never count on your birthday. Drum solo is coming up. Everyone get ready for a big finish here. I always do the double, the last hit on the tom with my right hand because I'm getting ready to do the crash on the cymbals with my left. I'm not sure if that's proper drum technique, but being an amateur drummer, that's how I do it. All right, we are going to jump to court with, let's see, we're going to back up just a tiny bit because the judge just barely walked in and I don't want to miss that. Okay, here we go.
Meeting room.
Yes.
Okay, can I just be put on the record for the exam date for Katie Ford when it comes?
If she's not on Zoom yet, so yeah, yep. When she gets on Zoom, then we'll do it.
All right, thanks.
You're welcome.
And Madam Clerk, we're ready on Sylvester whenever you guys are.
All righty, I'll let the judge know. Thank you.
Thank you. Yep, thank you.
This is Judge Oakley. He's had some epic moments. I love watching him handle Saw
Mr.
6.
Harris, you need to speak to the prosecutor, or do you want to speak to your client?
I spoke to my client. I need to speak to the prosecutor. Thank you.
All right,
And
I'll
the
put you in the
judge.
breakout room with him.
Okay.
Yeah, completely empty courtroom. A closet, some skyscrapers. This is what we have today. Big Sky DMC, 20 months, OG. Best crime watching on YouTube. Greatest mods in the biz. And RA with all his tech and cords. I'm getting more tech today. I'm so excited. So excited. Sloth Life member for 10 months. Oh, there's the judge. Good morning. Good morning, sir. Judge Oakley. Wearing a nice maroon, deep red shirt. Like that. Oh my goodness. Sloth Life, hope everything goes well with you and your cat and the bill for it. Thank you. Thank you for the thoughts and prayers for Dodie as well.
What was that guy's name we took care of this morning?
That was Gregory. It was the very first one. Joe, if you have any adjournments, just bring them into me, please, and let me know.
That's what it was. Thank you so much. Morning, counsel. Morning, Judge. How you been? I'm doing great. How's the old man doing? He's better than me. I always say he's going to outlive us all, Judge. Give him my best. I sure will. It's been too long. I haven't seen him. And a lot of people I always get asked about him because mostly right now, not completely, because he'll come here. But mostly he's farming the farther stuff out to me. Longer trip. Yeah. You know, if it's out of he's staying close to home. I don't blame him. I know he still comes here. Yeah. Yeah, good. I know he misses you, Judge. That's for sure. No, I'm just doing my physical regular, get back on my feet. And I still got till February, but I'm running and jumping already. Good. More than I ever thought I'd do again. Good.
Judge is getting the
Judge,
niceties.
can you ask Mr. Hall how long of a adjournment he would like?
I think if it's is it going to be on a Wednesday? Yep, every Wednesday.
Can you ask Mr. Hall to stand by the microphone?
It should be perfect on the 27th. If that's the day before Thanksgiving. I don't know if it's. We got a docket 27th, Heather.
We sure do.
All right, I will be here. And I appreciate it. No problem.
This judge does not.
We got anything online ready to go, Heather?
Yes, the Sylvester case, please.
I am ready. Appearances on Sylvester.
Thank you so much. Congratulations on 16.
Thank you. Good morning, 17. Your Honor. From the Department of Attorney General, Chris Kessel for the people.
From the Attorney General.
Sorry about that, Your Honor. May it please court, Tyrone Pickard appearing on behalf of Ms. Sylvester, who's present via Zoom, Your Honor.
Thank you. What are we doing today, guys?
Your Honor, I think we're going to ask for an adjournment. I'm going to get Mr. Bickerstaff the discovery in this matter. It is pretty heavy. It's about 500 pages. So obviously he needs to review it. So I was hoping, or we were hoping, maybe we could come back the first or second weekend of December for a PCC.
All right, so, yeah, we'll just adjourn the PCC. Let's take care of arraignment. Mr. Bicker, would you waive formal reading?
Yes, Your Honor.
I'll enter a not guilty plea. What'd you say, first or second week in December?
Yeah, whatever works for the court, I think would be fine for me.
Pick a Wednesday, fellas. Any Wednesday works for PCC.
Could we do Wednesday the 4th if that works for Mr. Bicker?
Sure.
That should be fine. That's fine.
All right, that's with Judge Green, so that'll be Zoom. Let's do it at, well, is Sylvester in custody or out? I can't find her on screen anywhere. Oh, there she is. She's out. Okay. Yes, so let's do this on the 4th at 9:30.
Works for me, Judge.
That's fine with me, Your Honor.
Ms. Sylvester, 9:30 on the 4th?
Yep, I just put it in. So will my warrant be cleared as of today?
Correct.
Okay.
All right. Does the prosecution have any position on bond?
No, Your Honor. We'll leave it to the court's discretion.
All right. I'm assuming she's a good risk for personal then. Ma'am, I'm going to put you on a personal bond. The first condition is the obvious one, stay out of trouble. The second one is just about as obvious. You have to participate in your court date December 4th. So that means you either have to be in the court so we can put you on a computer, or you have to Zoom in on your own. Understood?
Yes.
All right. I'm going to put you on a personal bond. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $5,000 if you mess up on bond?
Yes.
All right. Gentlemen, anything else you can put your hand down, ma'am. Gentlemen, anything else to take care of?
No, thank you, Judge.
No, Your Honor, that's all.
All right. You folks have a good day.
Thank you, Your Honor.
Mr. Pickard, did you speak to the prosecutor regarding Mr. Talis? Because
No,
he is.
I need to.
All right. Yep, I'll throw you back in there. And Judge, next we can do Pigott, Pigott.
Booth. Somebody brought him in. I don't know who did. Steve Booth? Booth.
We're waiting on Booth to jump on. Mr. Martin is here for that on Zoom.
Okay.
So we're waiting for that one.
And is it Pigott, you said?
Correct.
I'm looking for him. When's that one scheduled?
Pigott is scheduled at 8:30.
Is Mr. Martin driving right now?
Oh, there we go. All right, appearances on that file, please.
Good morning, Your Honor. Nancy Casta with NDS, appearing on behalf of Mr. Christopher Pigott, P number 80549.
Thank you. Mr. Pigott, you can hear me?
Yes, Your Honor.
Thank you. Counsel, what are we doing?
Your Honor, I believe the prosecutor wants to double check just to make sure that we don't have outstanding digital discovery on this case. So I believe we're requesting a 1-week adjournment.
All right, next morning or next week. Yeah, what time will we do that? That is the 20th. How about 9:30?
Perfect. We can do.
Judge, are you allowing that by Zoom or in person?
Why is it on Zoom today?
Heather, I think I'm going to be there in person on the 20th as well. I do have a perfect nation.
All right, let's do it live then.
Did you want it a little later, Miss Casto, then? If you're coming in for an exam, we can do it at like 10:45, 10:30, 10:45?
We can do that as well.
I mean, would that help with your exam?
It's going to be of Judge Oakley. It's going to be for Miss Ford, so whenever the court will give us that exam date.
Yeah, the exams are scheduled later, so rather than have you hang around all morning with us, we'll give you this one later in the morning.
Perfect. That
Mr.
sounds
Pigott, that works. Wednesday at 10:45, was it?
Yes, Your Honor.
Heather, 10:45?
Yep, that's good.
All right, bond is continued. We'll see you two next Wednesday.
Thank you. Mr. Pigott, you can go ahead and log off, sir, and then we'll be in contact, okay?
Thank you.
You're welcome.
Heather, anything else ready?
Mr. Wyatt, are you ready on Miss Kosab? I mean, Mr. Harris.
No, it's my understanding the prosecutor. That's fine. No problem. It's my understanding that the prosecutor and Dane is not here, and I just texted to see if she was.
We're not understanding anything you're saying.
If she's going to zoom in.
Miss Kosab's in custody. She's on.
Yeah, I understand Miss Kosab's in custody, but Aaron Dane, the prosecutor, is not.
Aaron Dane is the prosecutor?
Is not in custody.
That's my understanding. And I've texted her and she hasn't responded yet.
This is Ryan Parks. This isn't Alicia Kosab. Sorry.
Oh, well, thank you.
Sorry.
So
she didn't look like Miss Kosab.
So we are waiting for your attorney, Miss Parks. So we're not ready for, Miss Parks, are you able to see if, well, I guess we're waiting for Miss Dane anyway, so we're going to be waiting a few to put before we put Kosab on. But let me try and call Miss Dane. So as of right now, I don't think we have anything ready. We're waiting for everybody's clients to appear.
Thank you.
Judge just bails. He gone. So, yeah, Miss Parks is not Miss Kozub. So she gets to wait again because lawyer's not shown up yet. Lindsay Ann.
Mr. Harris, I don't have a phone number for Miss Dane, so I guess we're just going to wait.
First time live posting. I'm from the UK and just finished binging your Melody Ferris trial. Love this channel. Lindsay Ann, welcome. Good to have you. What part of the UK, if you mind sharing? I spent some time around Aylesbury, Watford, Rickmansworth, Kings Lynn, Hyde Park. I like that area.
I have a number for Miss Dane if you want it.
He sounds so robotic.
If it'll come through because you're really bad reception.
Okay. Let's see. Let's try this. 734.
867-5309.
I'm missing a number.
It was 867-5309.
73. Okay.
Is that it? Lincolnshire. Got a lot of people from the UK this morning, which is wonderful. UK peeps unite. Ask for Jenny. Been looking for her number, says Lindsay. Lots of Lindsays here. Wonderful. I didn't live in Hyde Park. I just spent some time there. Loved walking around Speaker's Corner Sunday afternoons. It's crazy. It's wild. Newcastle upon Tyne in the house. In the hoose. South Wales. Nice. Poppy's from London. I only understand where in London you are based on, if it's the district line or the circle line or, where the tube, which tube line were you closest to? Let's see.
Mr. Harris, Miss Dane's going to be calling you. She needs to speak to you.
Okay. Well, maybe this is her call. Thank you.
You're welcome. I do not show Mr. McKitty as in custody.
Lots of UK people
Okay,
checking in.
thanks,
awesome.
Heather.
Do you have a phone number for him, or do you want to verify the one that we have?
I have one, and it was not successful.
Because ours ends in 0553.
Let me see.
Is that the one that you have?
Yeah.
Yeah. Okay.
The magic roundabout in Hemel Hempstead.
I think it's scheduled at 10 o'clock for this one. So
still has your name on the side of it for going the wrong way.
Okay. So we'll be waiting. And that is, it looks like it's the domestic prosecutor.
Yes.
So you'll be speaking with her on that.
Okay.
Do you need to speak to Miss Ford or?
No, we should be good with Miss Ford. But give me 1 second, Heather.
Yep,
Sorry.
Yep. No, you're good.
The beauty of the magic roundabout is
Hey,
you can go
Heather?
around either way.
Yes.
I have all 5 defendants here now, including the 2 945s.
Perfect. Yeah, we're waiting on Miss Parks. Sorry, I thought you were somebody else. We're waiting on Miss Parks' attorney.
All right, well, let us know if you need to flip-flop them.
Okay, thank you.
Right. It's the attorneys we're waiting on. The Hemel Hempstead magic roundabout. First of all, I love that it still is there. I think it wasn't it like right in the shadow of it was like a Kodak building or something. There was a big building back in the day. I think it had something to do with film. I think it was Kodak. Anyway, the roundabout, a normal roundabout, it's a traffic. For those that aren't familiar, it's a traffic feature that treats an intersection such that nobody really has to stop if there's no traffic. You don't have to stop for a red light, wait for it to turn green. You just, if it's clear, you go. and you just check for the oncoming traffic, and then you zip ahead and make sure nobody's stopped in front of you. But because it's a circle, you can drive around it, and then you just take the exit for whichever of the streets you want to exit. Well, this magic roundabout has 6 little roundabouts where 6 roads come together. I think 6 roads come together. Yeah. It's got 6 roundabouts, which form one giant roundabout. And so you can go around.
Miss Parks, your attorney just emailed me, and he'll be jumping on any minute.
Determine whether by whether you're going around the outside or the inside of the big circle. Anyway, it's a blast. It's crazy. You've got to try it once, at least once in your life.
We would like to get in there.
We have a roundabout here in my town. It's funny because there's only really, it's a straight road, and it's like a T intersection, and they made a roundabout right there. I guess they thought they were cool. The Swindon roundabout. I've never been to Swindon. I have to check it. It's a little nerve-wracking because everybody that's in there is...
Okay, now it's working.
Everybody knows how to drive there unless you have never been there before. And then
Ms. Farage, it looks like Mr. Arnold is on Zoom now. Did you need to speak to him?
Yes. Can we briefly go into a breakout room?
Sure.
This voice in our head, the court administrator, is doing a great job. Have a roundabout in Bountiful just south of us. Where in Bountiful is the roundabout? Is that a new feature? It's been quite a while since I've been there.
Yep.
I think I'm going to probably ask to see if I can speak with Ms. Ford briefly. I just received notice that we might have a conflict in continuing to represent Ms. Ford.
Alrighty. I'll put you in a breakout room.
Thank you.
Just received notice that I might have a conflict. Oops. Okay. Magic roundabout in Swindon.
Heather?
Yep.
Yeah, I just talked to Miss Dane. We're looking to hold the exam. If we could try to hold it next Wednesday at 11, if that's good for the court.
Hold on 1 second. I'm trying to figure out where Miss Castow is.
Heather, I'm not on that case. It's Aaron Dane.
Yep. I spoke to Aaron.
Okay. And then
Thank you, though.
Yep. And then Nancy Castwell's case is with Patricia Manderman.
Miss Ford is?
Not Miss Ford, the other case. She has 2 cases.
Yep.
All right.
McKitty.
Yes.
Yeah.
Okay, let me put it on the screen. The Swindon is nuts.
Dane would like Mr. Muhammad to just stand in for to set that date. That's not a problem for him.
Yep. Next week, my exams, I have 1 o'clock. I don't have 11.
Ooh, she's got a 1:30 exam. Do you do any other days?
Well, my next day is December 23rd. Otherwise, no, the whole month of November is pretty much full.
Well, you said your next day is December 23rd.
They're going to keep doing scheduling for a minute. I'm going to show you the Swindon roundabout. Each little circle here is a roundabout. You can drive around it counterclockwise, or no, that's clockwise. Sorry, I got my directions wrong. But imagine there are 2 paths. First of all, they drive on the wrong side of the road over in England to begin with, so that's confusing. Sorry, there's the right side and the wrong side, and you drive on the wrong side. But you can either be the blue path right here and follow around the outside, or you can be the red path and drive right through the middle, and both would be legally correct, which is just nuts. And all these little weird shaped islands. That is just a crazy intersection. I say wrong side of the road, but yes, I've been in more car accidents in England that were my fault than I think in the United States. So
I would need Miss Dane here to figure out if she's available on those days.
Well, next week she's available.
I
either Tuesday or
We're not available though. I'm telling you the days that were available.
Oh.
November is not a good month. It's pretty much booked up. So if you want a different day besides November 20th.
Let's just set it for the 23rd.
December 23rd?
No, let's just set it for the 23rd. Let's just set it for December 23rd then. There's not much we can do about that.
Right
okay,
before
and your
Christmas.
client's in custody and you're okay with that? 23.
Pardon?
Your client's in custody.
Yeah, she's in custody.
Yeah. Okay. So November 23rd, I have 11 a.m.
Oh, I thought he said December.
I mean, I'm offering other days in the beginning of December, but if I need Miss Dane on to figure out if those days are any good.
Okay.
Otherwise, December 23rd at 11.
Okay. Let's set it for December 23rd at 11.
And that's a preliminary
Because I
exam.
don't have her schedule other than. Yes.
All right.
We're keeping an eye out for the Karen Read stuff.
All right. Then you're all set.
When it happens, we
I'll
may
send
be jumping
notice.
right over there.
Thank
you very much.
You're welcome. Mr. Martin, is Miss Booth going to jump on? I mean, have you talked to her?
I have no information to share. Just waiting.
Mr. Pickard, are you ready on Talis? Oh, no, you need to speak to, we need the domestic prosecutor on that. There she is.
Okay. People are arriving. Court's going to be here in a minute.
Well, then,
The judges.
then yeah. So you're going to hang out. I'll let the judge know. I don't know where he's at. All right. I'll hang out. All right. I'll let you know what's going on. Okay.
Mr. Arnold, you're getting a phone call. You can just ignore it. Yeah, just ignore it, and we'll just hear the buzzing noise.
All right. All right. Report now in session. Honorable Judge Oakley presiding.
Yeah, have a seat.
Judge, on Zoom, we have Miss Ford, Katie Ford.
Okay, appearances on People versus Ford.
Good morning, Your Honor. NDS by Nancy Casta, appearing on behalf of Ms. Ford, P number 80549.
And she's got a conflict.
And where's Ms. Ford?
She's on Zoom.
All right, good morning.
Good morning.
What are we doing, counsel?
Your Honor, I just actually received a notice that unfortunately NDS does have to withdraw from the case due to a conflict of interest. And I apologize to the court, but I just literally received the notice on that.
All right, so Heather, how fast can we get somebody else appointed? We'll set another PCC.
Do 2 weeks, and we can set another PCC.
All right, Ms. Ford, we're going to bump you out to November 27th.
Okay.
So we can get you another attorney. That's going to be with Judge Green, so that'll be a Zoom docket.
Okay.
I'll continue your bond. How about 9:30 in the morning?
Okay. Yep, that sounds great.
All right, any questions?
No, I'm all set.
All right, you're good to go. Have a nice day.
Thank you. I appreciate you.
Thank you, Your Honor.
And then the next one is Parks at 8:30, Ryan Parks.
Appearances for Parks.
Good morning, Your Honor. On behalf of the Defense Neighborhood Defender Service, Jonathan Cohen, P86151. Ms. Parks is present by Zoom in custody.
Thank you. Ms. Parks, can you hear us okay?
Yes, sir.
Thank you. Heather, while I take care of the the felony file, there's a DWLS charge from Van Buren. Let's get her. Oh, that's money. Never mind. We'll talk about that. All right, counsel, what are we doing on case number ending in 0969, the receiving and concealing?
Judge, I'm just asking you to set the matter for preliminary examination, if at all possible, within the 21 days from her arraignment on the warrant, which would have been November 6th. She's in
How about
custody.
next Wednesday?
Yep. Let me double check. That should be fine. But just want to confirm the 20th. What time, Judge?
1 o'clock.
Yes, I can do Wednesday, the 20th at 1.
All right.
Thank you, Judge.
We'll continue bond on that file. And Ms. Parks, you owe us money on a drove-while license suspended from Van Buren Township way back in 2015. We'll figure that out next Wednesday.
Okay, thank you, Your Honor.
Thank you.
Thank you, Mr. Cohen.
Yes, ma'am. See you soon. Have a good day.
All right.
Take those into Heather. Heather, anything else?
Yep, Arnold at 8:30.
Appearances for Arnold.
Good morning, Your Honor. Attorney Sahar Faraj appearing on behalf of Mr. Arnold, who appears via Zoom. Mr. Arnold, can you please unmute yourself and state your name for the record?
Unmute first.
Remember to click on your screen and hit that microphone button, Mr. Arnold.
We know it's working because we could hear your phone.
Can you hear me now?
Yes.
There you go. Counsel, what are we doing?
I got a slight problem. The volume just went almost all the way down on mine. I can barely hear you.
Can you hear your attorney?
Yep, I listen closely.
All right, we'll both shout. Counsel, what are we doing?
Your Honor, may we set this for an examination next week?
1 o'clock?
On the 20th?
Correct.
That works with defense.
Mr. Arnold, next week, Wednesday, the 20th, 1 p.m., my courtroom. That work?
Yes, sir.
See you
1
then.
1 p.m. your courtroom next Wednesday, right?
Yes, 1 p.m. Bond continued.
All right.
Thank you, Your Honor. You can log off now, Mr. Arnold.
All right, thank you. You people have a great day.
Heather, what else?
Well, I'm trying to find Miss Pravanchi. Can you please bring cast or COSAB out, please? We're gonna get ready to do COSAB.
She's en route.
Can I
Do we
take
see
something
Miss
in?
Mandernach? Did she leave again?
She's not in the courtroom.
No, but
Can I take care of some Miss
Yes.
Bowditch is in court. Can I take care of those?
Yep.
Mr. Bowditch, what do you want to start with?
Hey, yeah, this is Darcy. She's here. This man's here.
Good morning, Judge. Sorry, I'm having some trouble getting on Zoom.
All right. I don't know what I need you for. Are we looking for Mandernack?
Yeah, on Zoom.
What one?
I just emailed you. I'm restarting my computer right now to try to get on.
Which file?
Which file? What? For Mandernack? Dane. You're on Dane.
Do we see her before?
Tyrone Bickert Talis. Okay, Mr. Bickert is defense counsel on that. He's on Zoom? Correct. Okay, I will get on Zoom as soon as I can. Thank you.
Okay. Let's not do that again. Mr. Bowditch. What do you want to start with?
Oh, Your Honor, just making a difference. Why don't we start with this one? With Mr. Williams, all right.
And his file's right here. We just needed to set it for a final pre-trial. I was in the middle of it.
Good morning. Your appearance.
Your Honor, for the record, Judge Bowditch appearing on behalf of and with Mr. Chad Williams. Sir, could you tell the different name of the record? Thank you, sir. Your Honor, today's date time set for pre-trial. We are requesting a final pre-trial in which the complainant must appear.
Pick a Wednesday.
Pick a Wednesday. It's going to be a hump day. Which hump day do you want?
You know, I apologize. Can I
27th?
get my calendar?
Sure.
Ready, I apologize.
Don't go in.
Mr. Williams, stay right there. Oh, look at my calendar. He's leaving the court.
All right.
Where'd
It looks like.
Where'd you keep your calendar?
Oversight is an adjournment. And Booth is going to be Zoom? Booth?
Yes. Yeah, we're waiting. We've been waiting for her attorney for a while.
She in custody or out?
She's out. We had an exam this afternoon and he's waiting on her.
Oh, so she's not late. She didn't know they're trying to do it before this afternoon. 27th? That work for you? 9 a.m.?
9 a.m. fine.
All right, bond is continued. We'll get you a paper notice, Mr. Williams. Next file?
Mr. Klobuchar?
That's the adjournment.
That's an adjournment. Don't need me for that. Somebody that you need me for.
That's all I have right now.
All right. Mr. Klobuchar, we're going to get you a notice.
Your Honor, with Mr. Klobuchar,
Want to go to the same date?
we need to go as long as we can. He's meeting with Mr. Sick and the driver's license.
Going to the first of the year somewhere.
Hey,
I mean, we just pick a Wednesday, I guess. Doesn't matter who it goes to.
but I have to do notice for them to Zoom it, and or if it's in person, can I just do December 30th?
Yeah. We'll do December 30th. Who's Mr. Klobuchar? All right. If you don't have anything to talk about before December 30th, you let Mr. Bowditch know. You won't have to come in December 30th, and he can just get it bumped further into January. The problem is we don't have our 25 calendar set yet, so we can't give you notice. So just so it doesn't fall through the cracks here, we're going to set it for the end of December, but you communicate with your attorney, and he can talk to us, and we'll just bump it down the road. All right? Good luck.
John?
Yeah. We're going to get you notice for the December date, though.
Okay. Thank you.
Yeah, that'll work. Mr. Muhammad, are you ready on something?
Yes, Roy
Anderson?
I'm going to follow up with some investigated because I want to move forward. It's 5 years.
Sure. Is Mr. Anderson represented?
Yeah.
Good morning, gentlemen. Your appearance is for Mr. Anderson.
Morning, Your Honor. Josh Sheridan, on behalf of the defendants, Mr. Roy Anderson. Mr. Anderson.
Roy Anderson.
Good morning, Mr. Anderson.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Sir, what's your name?
Roger Anderson.
All right. Raise your right hand. The other right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth today? Yes. All right. Mr. Muhammad?
Thank you. Mr. Anderson, is it true that you don't want to move forward with this case?
Yes, it is.
Right.
And are you making this decision freely and voluntarily?
Yes, I am.
Have you been threatened or coerced in any way to come to this decision?
No.
Okay. And would you be assisting the Wayne County Prosecutor's Office in prosecuting this case?
No, I would not.
Okay, Judge, based on that, we're unable to move forward, and I would request a no late response.
Done.
The victim refuses to cooperate.
All right, Mr. Hadley, anything else?
No, Your Honor.
No late. Thank you, sir. Mr. Anderson? Mr. Anderson? Good luck.
Mr. Anderson.
Mr. Hadley, could you approach? When you can.
Yeah.
Oh.
Yes, sir.
Is the son the caregiver?
Sorry?
Is the son the caregiver?
No.
No.
Okay. Are there resources they need?
I don't think so.
Okay.
I think it's good old fashioned family.
Okay.
Family resources, though, I may have a situation where I've got, they're all here. I have a complainant who appeared at the last final pretrial. I took the case over for Kaplan. The defendant is on dialysis. Ugh. They're married, and he can't go home.
Right.
Because, she's not going anywhere. They're married.
Our next big trial starts on Friday.
Anything out there in the way of temporary housing assistance, even need for people who are in medical situations like that? Not
talk to Avery. Okay. He might have his contact at Wayne Metro might have something. She's not willing to let him come home.
No, it doesn't sound like it. I'm going to go talk to victims' rights here in a minute. She's not. Actually, Mona's not here yet.
But you might touch base with Avery and just tell him what's going on, and maybe while you're working on other stuff, he can make a phone call or two and see if there's anything.
The plea offer, if accepted, or a finding of guilt, is going to still result in the same kind of scenario.
Right.
Like they're stuck.
So it might not be real temporary.
Well, at least in the immediate, they need to get down to family court.
Right.
It's a 20-year marriage. It's 30. So it's one of those I was just kind of like, didn't really have a good answer in my toolbox for that.
I just want to make sure it doesn't get worse.
Yeah. I'll check with Avery.
Yeah, check. That's my only suggestion.
Yes, don't worry.
Yeah.
Mr. Pickard, did you need?
What'd you do? Oh, that guy?
It's not the law. That was the Jedi.
No, I think that was magic. What, you work some magic.
Did you need to speak to Mr. Talis?
She asked me, like, do you need to talk
to Mr. Talis? Yes.
And I'm like, he's going to be held in contempt.
Wait, no, I mean, Mr. Talis spoke.
Sorry.
No.
Really?
No, but I think the way you sold it to just dismiss it with prejudice, get your attorney to refile it, sold it.
I felt bad for him because I think
We're just asking for anything on that one.
he might need mental illness.
It's obviously mental illness.
And when he said that.
Yeah. No, I think.
Hopefully that's the
point. I think you showed him a way to save face, and he took it. And I hope they get him an attorney. I hope they get him an attorney to talk to him.
I can't.
Yeah, and maybe he'll listen to that person.
Here, do you have that beat one?
Yes. That's the one. No, wait. Of course,
Got a camouflage defendant walking in.
But with the attorney here, we can just have him.
Janelle's not.
Hello.
Hello.
Good to see you.
They're grabbing it, right?
Yeah.
Okay. Did they send it back around? I can't read it.
Yeah, you guys sent it in
Well,
for signature, but now that you're here, you can sign it original.
I'm still not sure I'm doing it, just so you understand.
Okay, so what do you want us? I mean, it's going from an operating impaired to an operating recklessly.
No, I know that, but I'm not sure I'm going to take that plea. You're not going to convince me. We've just never done it. We've always required a dismissal and a new ticket. His office says they won't do that.
No, it's not that we won't do that. I just wanted to I asked Heather if she can make sure like that you guys aren't going to be accepting that. Because it's still they're both misdemeanors.
I understand.
I think we're going to
exactly what you're trying to do. We don't do that.
What time does it start?
So I'm trying to decide if I'm going to change my policy.
Okay.
And I'm not going to do it because you guys asked me to.
Of course. I mean, it's whatever you think is right.
I mean, I'll do it if you want to dismiss and do it the way we do it. If you want to dismiss this one and have a new ticket issued for the careless or reckless, whatever it is, we'll do that all in one day. But if you want to do it as a reduced charge, I'm not willing to say yes or no yet.
Okay.
Because I'm checking. Basically, I'm just rethinking policy that we've had for forever, and I'm just going to see if there's a real good reason. Because I got it handed to me when I got here. Mm-hmm. So
what was the issue with the judge saying?
Well, because it shows up that we're reducing drunk driving to non-drunk driving. You know, back in the day when MAD used to, put judges in headlines, and that gets labeled to an individual judge. Mm-hmm. So I'm not worried about that, but I just want to make sure there's no other reason not to.
Wow.
Well, they got to get an officer here for that. That's the problem. You got to have an officer here. Who is this? Which department?
I didn't.
Hmm.
Because it's normally if it's an OWI, we go down to impaired.
No,
it's already impaired.
I don't care what the end result is. That's between you guys. I'm just talking about process to get there.
I understand.
And you had this conversation. It's your charge. If you want to dismiss the damn thing, that's on you. That's not on me. I might think it's a bad dismissal, but I'm not. It's your case. It's your purview.
I understand.
Just the process to get there is what I'm questioning. And I just don't expect here. We contacted our regional director to see if Scales got an official opinion on this, because once again, this is something I inherited when I got here, and we've always done it that way. We've never had anybody push back to it. So now I want to see if they've got an official position on it.
Uh-huh.
If they say no, then I'll do it. But if I can't get an answer because Janelle is out of the office today, so we're just going through like the general courts ask questions thing.
You want to put this off, Judge?
I can do it that way.
Yeah.
I don't want to put either of you guys on any spot.
No,
Hey, why don't we adjourn it for you to get that answer on?
I'm okay with that.
Approach the cop just in case. So we can get it done next time.
I don't mind changing my mind. I just want to have a reason to do it other than just you guys asked me to. Not that I don't like you.
There are issues.
No, I understand.
Oh, I'm sure there always are. Yeah. Once again, I'm okay with where you're going. That's his decision. It's the process how we're going to get you there. That's the only thing I'm questioning. So if you want to adjourn it, that's fine. I mean, I'll probably have an answer in the next day or two. So it's not like we got to kick it down months.
So why don't we adjourn it for that? Because I don't want to put you in
I can put you on next Wednesday.
And next week.
Are you available? Or do we have to? The problem is I'm leaving town tomorrow until Tuesday. Okay. Next week? And we couldn't Zoom it Wednesday if that helps. But I mean, if you're trying to get it done before Wednesday, I'm just not available.
Just Wednesday, I have an in-person in the morning in Clinton County.
No, can I Zoom you Wednesday? Because all day Wednesday, I'm going to be here.
Yeah.
Can we do that?
Yeah, I'm okay.
Okay.
Yeah, we could even do it. We could do it between exams in the afternoon if that helps you. That's what I want to do it in person.
Take my cell. I'll give you my cell phone.
Well, you know what? Hold on.
You can do it by Zoom?
Yeah.
Okay.
Let's just do it by, because we can take a plea to a new charge too if we have to, if that's what we're doing.
Oh.
Right?
You want to look at it, talk to that cop and see what we want?
Do you have the ticket?
I don't want to get you in trouble with your office.
Just want a name?
No. The thing is, my chief reviewed made it. I'm just going off.
Well, I get it.
And you know, I'm a hard ass enough to say that their office don't set my policy. So that's what this is about.
We're here for a little while. Okay, so Wednesday.
I don't have a ticket, but it looks like Carrier was the officer.
Officer Carrier?
No, Carrier's the defendant.
Okay, I could figure it out.
This is an interesting little dilemma.
I can't find a name on this incident report.
Don't worry.
A DUI that they're going to plea down
Okay, I'll
to
see
a
you next week.
non-DUI.
Okay.
Yeah, sorry, Mohammed.
No worries.
Judge says, I
you
remember
don't have to
when
do anything. So,
MAD,
we're
Mothers
just
Against
gonna
Drunk
hurt it, so
Drivers, were putting billboards up about judges that were reducing these sort of charges and shaming them to get them voted out.
Okay, we can't come to a resolution and leave it.
The judge has no
We'll
problem
get here one way or the other.
with the actual reduction.
Yeah, we'll get here.
He just doesn't
What
want it to
time
be on
next
him.
Wednesday?
10:30 on Wednesday.
And that's Zoom? Zoom?
By Zoom.
Okay.
10:30. 10:15.
James.
I wrote 10:30. Make it 10:30. All right. And you're gonna go, no problem. Sorry to slow it down. We'll get notice for your call.
Okay, thank you.
I think did I write the motion for a KPS on James?
We're waiting for the time.
If you can call Talis.
Thanks.
Patricia's going. Talis.
No, good.
Mr. Weinberg, can you sign the, I have it on in that office sign. It's fine. I have the one in the office that signs. Here's for you and client.
Thank you.
Thank you. Have a great day.
Thank you.
Okay, Heather, we got another sovereign coming in.
Oh, here we
Got
go.
another sovereign. Now he wants my employee identification number and my W-9. I wasn't under the, I didn't understand that he was paying me or I was paying him. And he's a smoker.
When's he coming in? We can't miss this one.
Mr. Bicker, you ready on Talis? Yes, okay. Yeah.
Patiently waiting for a.
Oh, is that ready?
Sign that. Yeah. I had to go to 9:45.
That's just going down.
No, it's Capus. Then where am I doing with this?
Andy downstairs.
Andy downstairs. Okay, I'll get that right now.
Oh, okay.
Joe, I'm confused. Who's waiting for this? Oh. Counsel, you're on James Sharp? All right, go ahead. Put your name on the record.
Mayor, please, is on the court, Don Tucker Davis, representing Mrs. James Sharp. My bar number is 5969.
And you've had no contact with him?
I'm not, and I'm trying to know what was needed by runner.
All right. He's going to go back in our pile for bench one. Have a good day.
You got the number that ends with 7096. He lives in Stockbridge.
Yes, I do. I've tried that on another number that's not unreadable.
Perfect. Thank you.
Use that address. Thank you.
Have a lovely day. Is Mr. Bickert ready on Talis?
He's ready on Talis.
Mr. Bickert, your appearance
Yes,
on
Your Honor.
Talis, please.
May I please court, Your Honor, Tyrone Baker, appearing on behalf of Mr. Talis, who's present, I believe, via Zoom, Your Honor.
Yeah.
Mr. Talis, are you out there?
Yes, sir.
You can hear us okay?
Yes, sir.
Thank you. Counsel, what are we doing?
Your Honor, I'm respectfully requesting to examine this matter.
Next Wednesday work?
It does.
1:30?
That'd be fine.
Mr. Talis, that work for you?
Next Wednesday, 1:30.
That's live.
I don't even know why I didn't script mine.
I'm really sorry to interrupt, Judge. I'm having trouble hearing because I'm having issues with Zoom. This is Mr. Talos, and was it being set for?
Exam next Wednesday, 1:30.
Okay, thank you so much. I appreciate it.
You're welcome. Mr. Talis, you understand that's live in my courtroom, correct?
Okay, in the courtroom.
Yes. Bond is continued. Any questions for Mr. Pickott?
No, sir.
See you next Wednesday.
And I'm sorry again, Judge, was that 1:30 or 11:30?
1:30.
Okay, thank you.
Your Honor.
Can you let Ms. Kosab know that we rescheduled her exam for December 23rd?
Ms. Kosab?
Morning.
We have scheduled your exam for December 23rd.
Okay.
At 11 a.m. Your bond is continued.
Okay.
Thank you. If you can flag down the deputy, you can let him know that we're done with you.
Okay. I will go see if Dan has his Zoom up. When they jump on, have them
Which file?
either Riggins or Shoot.
Corporal? Good morning.
Good morning, Corporal.
No, you're muted.
You're muted.
Sorry about that. I forgot my lines.
That's all right. Good morning. We're ready for either Riggins or Shoot.
We're gonna do Riggins, then we'll do Shoot.
It's your call.
Got a runner.
Yeah.
Good morning, Your Honor. I have defendant Devon Cordell Riggins.
Thank you. Good morning, Mr. Riggins.
How you doing, sir?
Better than I deserve. We're just waiting for your attorney to show up.
Yes, sir. Yes, sir. Yes, Your Honor. Ooh, it's been a long 15 days.
just putting it out there. It's been a long 15 days in jail. Time travels slowly in the clean.
Hey, I've got Mr. Riggins on Zoom from the jail. I'm not sure who out there representing. I don't know if it's Bowditch or Hadley.
Okay, let me find out.
Thank you very much.
All right, bye.
Who's Riggins' attorney?
I don't know.
We're giving them the card.
Oh, okay.
Yeah, they both just need MIDC and Dan's on another Zoom.
Okay, so we're not ready for him. We're just going to put him in a breakout. Okay. All right. Mr. Riggins, we're going to put you in a breakout room with the attorney. We've also got, just so you know, we got some cases coming up for a pretrial on November 21. Looks like trespassing, possession of paraphernalia, another trespassing. You know about those?
I thought that's what I was here for, all them.
No, today is defrauding an innkeeper charge from July 16th.
Defrauding an innkeeper.
They might have all came out of the same incident. I don't know. But one of them being prosecuted by the Wayne County prosecutor. The ones I just gave you are being prosecuted by the local prosecutor.
Okay, I thought they was all in Romulus, all the same.
All right. Hey, good morning, Dan. We're going to put you in a breakout room with Mr. Riggins. I just told him he's got 4 Romulus misdemeanors scheduled for pretrial next Wednesday, the 21st. I don't know if these are all out of the same incident or not.
Okay.
You're putting the breakout?
Yeah.
I'm going to get some water.
Oh, I need Nicole James' phone number. Can you write down 313? 100.
We're looking to see if we can find the hearing for Karen Read, which should be starting in just a few minutes.
Yes.
His attorney?
It's his attorney.
We have a prosecutor's asking for a ticket for John Seaman for disorderly. He has a domestic too with it, but he just wants the ticket.
Okay. And last name is Seaman?
Yes. For 2 files there?
Yep.
Yeah, he only wants a disorderly. Thank you.
You are welcome.
Corey May, love it when I comment on 10-minute-old material. Welcome to the future. Then realize it. Yes, it's great. Sometimes we're stuck in a time warp. Attorney Pickott looks like he just threw on a shirt, tie, and suit coat and might not be dressed from the top half down. The background showing the skyscrapers clearly indicates that he is not there.
I think that's all he wants.
Seems to be a bit.
I just saw his message. Yeah, because she might. I don't think we give copies to people to just show up. I worked with Sandy this morning.
I'll do anything.
Okay, yes.
Ms. Carson, did you speak to the clerk?
Yes, ma'am, I did.
Thank you.
I said, are you afraid the boogeyman's going to get you when they keep like the first guy, Bishop Boss, he's been here since 81.
Why didn't he leave? He's done. We told him to leave. We were mailing him out notice.
He hasn't, no attorney.
No attorney.
Ooh, I'm loving it. Bum, 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 bum.
So we have to send competency paperwork to the competency people.
Was he in
here? Yeah, we already took care of him. He's already talked to the judge and everything.
He said he's sitting here waiting for his attorney.
Mr. Gregory?
Yeah.
Mr. Gregory doesn't have an attorney. Gregory refused an attorney, even while he's speaking to the judge.
Today?
Today.
Was he have his mom with him?
No, he had his dad with him.
Oh, that ain't him.
Okay, so who are you?
I thought it was him.
No.
Okay, let me go find him.
Yes.
Because whoever it is, the attorney hasn't showed up.
Oh.
Bailiff's going to go sort this one out.
I know who you're talking about, right?
There is a Karen Read hearing today. I believe it's a motions hearing. So I'm not sure if a decision is going to be made, but possibly some argument. We're watching for that. Shut everything down so we can get Karen Read in the background here. All of our Georgia paperwork. It's in order. Any minute now, we might get a feed on Karen Read. We'll jump there if we can.
Has an attorney choked up here?
Choked?
CHOATE?
No, I don't know now. Let me go Doug here or something real quick.
Has a attorney choked? CHOATE appeared? Well,
Like
she
deja
has
vu.
one at 8:30 and she has one at 10 something. 10 o'clock. For MATO, MATO, the attorney at 8:30. The attorney never appeared. Oh, okay, thank you. Yep, thanks.
Okay. Looks like everybody is waiting for the feed for Karen Read. Willow Johnson, welcome. Good to have you here. We're going to be jumping to Karen Read here as soon as, if and when, they provide the feed for us.
Well, you guys know which. What do you think like in the dark? Same thing we're ready. We're ready. Well, you ready anything? No. There's one guy out there.
Ray Sean Reed? Is that the guy that's
I think part of the hearings we're going to hear today on Karen Read involve her dad's cell phone records.
She'll be here in a half hour. I just don't want that guy to get benched for, because his was the first case.
Oh, the one that we're waiting for Miss Nicole James.
Yes.
Okay.
So, and the other guy,
It's Green.
he's not due till 10:30.
Right, right. He's just waiting for what's his face.
Yeah, we're waiting for a term instead.
Waiting for what's his face?
Yes.
So nobody knows counsel's like
There's a guy sitting out there, he wanted to come in, they told him, well, just wait for votes, because votes should like to bring it into the report.
Yeah, exactly.
Pretty much caught up.
Sorry, I'm keeping an eye out for the feed.
Let's see, the judge comes out from Gary. It's more speed.
And just fine, how about you?
It's not, don't you mean?
Nothing in there, anyone?
Everyone I wanted to win won.
Look at it.
The one I really cared about.
Pickles, not politics.
Yeah, I told mom when he came over, I said, oh, you know, now that you use me, you got what you want out of me, you're gonna take my lawn decorations.
Yeah.
Jeez. What a awful person he is.
What do you get? But don't get hurt. No, that's not good. That's up.
I don't think that's secret thing.
It basically says what disqualifies you from taking on. Ready?
Ready, Your Honor, Mr. Redding.
All right, your appearance.
Your Honor, for the record, everybody, hearing on behalf of it, and with Mr. Redding, this is approaching, sir. Could you tell the judge your name for the record?
All right. Good morning.
Thank you. Your Honor, we have the prosecution. We met with Mr. Redding for the next subject to court approval. In this agreement, Mr. Redding would be pleading guilty to the added count of allowing an unlicensed driver to drive a vehicle. Also, with the understanding the original charges were dismissed, Mr. Redding adjourned to complete his license process.
And he did.
He did it. It's been verified by Detective Lawrence.
Awesome. Heather, the docket's showing 3 files.
It looks like the A case was done once.
That's what I'm looking. That's what I'm thinking.
Yeah.
Okay. I got 2 files, but the docket has 3 listed. I think one's just a duplicate print. All right. So, Mr. Redding, did you discuss with Mr. Bowditch your rights and the options those rights give you?
Yes.
Understood those. You understand the possible penalty for the added charge?
Yes.
All right. Well, Mr. Bowditch, I am not going to take a plea to impeding traffic. I'm just going to hit him a little harder on the fines and costs for assuming.
Thank you, Your Honor.
Or allowing, I mean.
Thank you.
All right. All right, sir, you understand the possible penalty for the added charge, yes? You understand your rights, correct? Understanding all of that, are you pleading guilty to that charge freely and voluntarily today? All right, what do we got? 9/9/24. Did you drive a vehicle on that day while your license was suspended, revoked, or denied in Van Buren Township? I will accept your plea to the new charge and dismiss the original.
Thank you.
And got his license. Are you working, sir?
My last week was, last Friday.
Where at?
County.
Oh, okay. All right. Well, now I know why that job quit. So what's next?
So I started my CNA class in December to get my
Good.
license back. So I'm already doing CNA.
Where do you do that at?
Residential houses.
No, I mean, where are you doing the classes?
Oh,
All right.
Mr. Reddy did suggest to me that in deference to fines and costs, he said, is there any way I can do some work? And I told him that may be possible.
Yeah.
I just lost my job.
All right. So here's what I'm going to do. On the one file I'm taking the plea on, I'm dismissing the speeding ticket as well. I'm assessing fines and costs of $700. That money's due within 5 days. That means you either got to pay us or have a plan. I'm going to send you downstairs to talk to Mr. Taylor, and he can give you a plan. He's got some different options instead of just cash. So some cash, sometime, all time, he's got options. Understood? Question?
So when you found in the counter, just ask Mr. Taylor. He's an imposing.
All right. Good. Have a good day. Good luck on the license, or good job on the license. So shoot, what was going on with shoot? That bigger? Shoot was in custody, wasn't
Shoot, yes, he's in custody, but the tower is speaking to Riggins first.
he? Yep. No shoot. Oh, let's do this. Hey, you got time to run through your docket to give me some no-shows? Thanks.
You want me to bring Riggins in with the court?
No, I need to file.
Riggins file? Riggins?
Already on that one.
What's the name?
Seaman. 2 files.
He'll be your next. He's in custody as well.
Orange is here. Orange is here. Thank you. She's coming tomorrow morning. Oh, great. Perfect. Yep. All right, counsel, your appearance on the People versus John Seaman.
Good morning, Your Honor. Daniel, we have for Mr. Seaman. Mr. Seaman, come out here, please.
How far out we want to go?
It's going to be on a Wednesday. Why don't we do?
The 27th work for you? November?
We're going to be on Zoom that day of rain.
And that's,
It'll be Zoom.
Oh,
Her docket.
all right, there you go. Let's do that.
That gives them enough time to get notice out.
and what is it for?
Final pretrial, complainant to appear. What time's your first one scheduled? The other file? With Judge Green?
Oh, I was counsel that day, Judge, so.
Oh.
Yeah, anytime's good.
Let's just set it at 10 o'clock then. That work for you, sir? All right, your bond is continued.
That's on both files, Judge?
I've only got one file.
Somebody took the other one, because that's on the domestic and the disorderly, the state prosecutor took.
Yes, Brian has it.
Okay, I'll go through it and bring it to you, Judge. Just have a seat. You have a second file on Stephen? The floor right here. Is that fair?
Yeah, the order.
Yes, okay. Okay, needs to see what's going on there. Judge, can I approach?
Yeah, we're doing the same thing?
That's the second file on Mr. Seaman.
We can get some audio here from this.
Have the third-party record holders been served in all of these?
Give me a second to get video pulled
Commonwealth
up.
motions pursuant to Rule 17?
Thank you, Your Honor. I understand the court might have a preference that I remove to the podium. Would you like me to answer?
It's wherever you're comfortable, as long as we can hear you.
Your Honor, I filed a series of Rule 17 motions, as I'm sure you're aware. I have not notified any of the third-party holders. I did not want to be presumptuous, seeing that I have not met the court and didn't know what the schedule would be for the Rule 17s.
Oh,
So I have filed these just to give everybody as much notice as possible. And my intention was to ask the court if we could set a date so that we could have these motions heard and hear the defendant's objections.
Okay. All right, so I misunderstood. I thought they were on for the Rule 17 motions today. All right, so the record holders do need to be heard. I was wondering why I did not hear from any of the parties, other than I have the defendant's objection to Mr. Reed's records. But all right, so we'll get a date, and that date should be sooner rather than later, to get notice out to all the parties.
Yes, Your Honor. I'll note that we did file 2 additional Rule 17s last night. I don't know if they've been docketed.
They have been docketed. I got them, and that's why I was wondering whether the record holders had in fact been notified. So, okay, so scheduling we'll do at the end of the hearing. Then I think what we'll start with after these Rule 17s that we'll put on pause, it's paper number 48. It's the defendant's motion for relief from the order to impound sidebar conferences. And before we begin that, is there an opposition to that from the Commonwealth?
In part.
Okay. All right. Have you spoken with Mr. Yannetti about what part that is?
I've spoken to all the attorneys numerous times. I think we're very clear what each other's position is.
Okay. All right, why don't you, all right, Mr. Yannetti, do you want to be heard by starting with the whole motion, or what?
I think we can short circuit this, Your Honor. Our suggestion, I think it's a joint suggestion to the court, is that the sidebar conferences be unsealed solely for counsel at this point. Mr. Brennan's at somewhat of a handicap because, unlike the defense team, he was not present at sidebar. He does not know what the conferences were about. And in fairness to the Commonwealth, we've agreed that it just be released to us, and then Mr. Brennan can decide if he has a further position regarding unsealing it more than that.
Okay. All right, that makes sense. Have you spoken with Ms. King about how long it will take to get these transcripts?
My co-counsel has spoken to her only...
Which co-counsel?
Mr. Jackson.
All right. What do you have to say about that? How starting with the whole motion, or what?
I think we can short circuit this, Your Honor. Our suggestion, I think it's a joint suggestion to the court, is that the sidebar conferences be unsealed solely for counsel at this point. Mr. Brennan's at somewhat of a handicap because, unlike the defense team, he was not present at sidebar. He does not know what the conferences were about. And in fairness to the Commonwealth, we've agreed that it just be released to us, and then Mr. Brennan can decide if he has a further position regarding unsealing it more than that.
Okay. All right, that makes sense. Have you spoken with Ms. King about how long it will take to get these transcripts?
My co-counsel has spoken to her only...
Which co-counsel?
Mr. Jackson.
All right. What do you have to say about that? How quickly can she get them?
She works extremely expeditiously, but she has not started them, to my understanding. There's 3 reporters who probably would split the work, and she said that she could get started as soon as there was a court order suggesting that she do so. I would imagine, given what we've gotten so far, we're talking a couple of weeks rather than a month or 2. I think we could probably get something within a few weeks.
Okay.
2 to 3, I would guess, just based on my experience with Ms. King.
All right. Even though it's just for counsel, do you intend to have, are you asking me to unseal the sidebar conferences with the jurors?
Just for counsel, yes. I would imagine that when we get to the second stage of this, those would be in a different category from the legal rulings at sidebar unrelated to yours.
All right. All right. Thank you.
If I could be heard briefly?
Sure.
Thank you. Regarding the non-juror information, I'm in full agreement with the defense. I think it's prudent to, if the court would consider unimpounding the documents, I can review them. If I have any... You
can review unimpounded documents. Counsel can review impounded documents.
Then I'll begin that task. And if there's any concerns, I'll note them. If not, then I would have no concern about releasing them outside a protective order. The juror information stands in a different posture, in my perspective. I think that should remain impounded at this point. There's a pending appeal before the SJC based on the request of the defense. If they are successful, would then reinvigorate the attention on those jurors. I don't see a need for juror information to be unimpounded at this point. All the other information, I don't have the same concern.
Okay. All right.
Okay, so we followed all these motions. We read them
All
all.
right, the next motion.
They get the sidebar information with the jury discussions about jurors.
So defendant's motion for discovery of communications in the possession, custody, and control of the Commonwealth. Who's going to argue that?
I will, Your Honor. I would say at the outset that in speaking with Mr. Brennan, he had expressed a preference to be able to respond potentially in writing. So we were in agreement, subject to the court's approval, if we're going to get another date for the Rule 17 motions, to have this motion heard at that time. But I'm prepared now if the court prefers me to argue.
I'll give you the opportunity. How much time do you need to respond in writing, Mr. Brennan?
I can respond by next week.
Okay.
Really, I'm accommodating the defense. I have a very broad perspective on Rule 14 statements. Our office has made a concerted effort to provide everything that's not only discoverable under the rule, but from my perspective, a broader perspective. I want to make sure I err on the side of caution and they get every statement they're entitled to. Okay. So we're in the process of accumulating all potential statements of witnesses which they're entitled to, and I'm going to provide them to them. I've already provided a number of statements that I frankly believe are outside Rule 14 parameters, and I'll continue to do that throughout this case.
Okay.
And so my response in writing really is to accommodate the request and then give an answer in a production of what I have. That's going to take me probably 10 days to put everything together, to adequately review it, and then to provide a package to the defense. And so I think that if I have 10 days, I might be able to accommodate the request without any need for litigation. If they decide to pursue further effort, then I can respond.
Okay.
So they get all the
All right.
information, the
So
additional
why don't we give
conversations
you-
they had with potential witnesses. Karen Reed, that was something that she asked for in one
Give
of her
you until the
motions.
27th, just after, or just before the Thanksgiving break?
Appreciate that. Thank you.
Okay. All right, does that work for you, Ms. Giannetti?
Certainly does.
All right, so let's talk about the Commonwealth's notice of scheduling, reassembly and testing of the defendant's Lexus telematics system.
May I?
Yes.
This might get
As a matter of background, as I think the court is likely aware, the Commonwealth tested information on data chips that were found in different modules that were inside the defendant's Lexus. Inevitably, at trial, the court is likely aware that there's information taken from one of the systems that was provided, and it showed information such as key cycles and different speeds. And I understand that was a exhibit at trial. There were two different search warrants by the government. One search warrant was for the car that included both a telestream and a telematics module, which is like a lunchbox with computer panels in them. And then in 2023, there was a second search warrant for the infotainment system, which is what was produced at trial. I hired an independent expert, and in the independent expert of the information, what he realized is that the information taken from the informatics manual and the information taken from the telestream manual had some irregularities. What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. There was information including navigation information, information regarding phones that were plugged into the radio, travel logs, things that are particularly relevant and material in this case, information that is going to be extraordinarily inculpatory or exculpatory in this case. And so after he realized his oversight on the gigabit, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader, so that way the information was not available. Also, in the the infotainment system, there were actually 3 boards, not 1. Only 1 was taken out. So there is a plethora of information on these chips that has not been downloaded that's relevant to this case.
Or a plethora?
And so we provided notice to the defense that our intention is that we are going to test this information that we have in our control and that we have a search warrant for. And my effort was to give them notice so they could have an available expert.
This is huge.
So my purpose really was not to ask for the defense's permission, rather it was to notice them this is what we were going to do. You can see from my motion I asked to do it within 14 days. Having recently arrived at the case, it was important for me to prioritize Rule 17 motions and new experts so that they could have adequate notice. The defense asked for today's date and wanted more time, and when I considered it, I thought that was reasonable. I think they are entitled to have an expert and consider what we are doing, even though I don't believe they have standing to prevent it. And so that's why I agreed to this date. Inevitably, we know that this information will be on these chips. And so we know there are 2 boards on the system that weren't tested, and then the other chips that were tested that came back with unreadable information with the proper computer programs, they call them programmers, we will get viable information from both of them. And so I've spoken to the defense. I know they've hired an expert. I know they filed a motion contesting our position. I'm not going to speak for what their position is today, but I would say 2 things. One, the defense in their motion asks to have their expert be able to intervene. We're not agreeable to that. They can watch and comment and criticize as much as they'd want, but we're entitled to the download. Notably, when the first download was done, the Commonwealth deferred to the defense expert to do the download. That is not my position. I don't defer that responsibility. But it was the defense expert that overlooked the proper reader that was needed for the chips that were tested, and it was the expert that overlooked the fact that there was 3 panels in the system, not 2. And our expert was astute enough to find those oversights, and that's why we now have an independent expert that is going to do this. I know experts differ. They're not frick or frack. They all have different opinions, but we've attached all of the protocol, what we intend on doing, and the reason I brought it before the court is I wanted to expedite this matter. It's important, and it...
I thought we were going to have that hearing within 14 days when we first got the motion, and then Mr. McDermott told me that the defense was looking for more time, so we gave this. But we're far into the case is scheduled currently for January 27th. Sounds like you have a lot to do before then, but as of right now, it's still January 27th, so all of these things, the Rule 17 motions, all of these things need to be done as soon as possible. So
I understand. And if I can just add, it might help in your consideration of a later motion. The reason why this is urgent to me to have this as soon as possible is because I also have noticed and hired an accident reconstruction expert. And that accident reconstruction expert will necessarily rely upon the information that is gleaned from this testing.
How long is this testing going to take?
It's a 3-day testing. It will take within a week to read it. And the sooner we have it, the sooner we can have our reconstruction expert engage in any type of task that we want them to. But they necessarily are in a holding pattern now. And that is my sense of urgency for this to be developed and done.
Who's arguing this for the defense?
This could seal the case.
Okay.
One way or the other.
Mr. Jackson?
Thank you, Your Honor. I'll start by saying in principle, we don't have an objection to the retesting of the telematics or the infotainment center or system data. The problem that we have, our issue, sort of dovetails into what Mr. Brennan was suggesting about what was done the first time. He just suggested that his new expert, Mr. Shannon Burgess, was astute enough to find something that Maggie Gaffney didn't find. Well, to bring the court completely up to speed, when the initial testing was done, the Commonwealth's expert did not know how to do a chip-off, physically did not know how to do it, the Joe Paul. He turned to Maggie Gaffney, our expert, who did know how to do it. She's a former MSP officer and extremely facile in this world of
And you have a different expert now. You're not using her now?
Well, we may use her, but we have an additional expert who specifically works, Mr. DeSorga, specifically works in chip-offs and chip-ons. That physical that physical procedure of moving chips on and off of boards. It's a very technical procedure. It's a very skilled procedure. He knows how to do it. He's got an extremely long resume. Having done this kind of work, we're bringing him up to speed in order to sort of engage in some oversight and some observation. I don't have a principled objection to doing the retesting. What I have a problem with is that their new expert, Mr. Burgess, right at the beginning, fundamentally misunderstood the data set on the 3 chips, the 2 micron chips and the expansion chip that he looked at, didn't understand the difference between megabytes and megabits, gigabytes and gigabits, and that gave us pause. If he didn't understand that, which is at the foundation of reading the data, we're concerned that some of the data could be destroyed in whatever process he engages in. Like I said, we don't have a principled objection to the work that's going to be done. We simply want to make sure that nothing is destroyed in doing that work. It's not, and I would take a little issue with something Mr. Brennan said, it's not that the data set is missing information. We don't know that it's missing information. Burla has now updated software that we believe, I think both sides believe, could be beneficial in culling or teasing out that data set from those chips. That didn't exist when Ms. Gaffney did her work previously. She put it on a reader, it was unreadable. It doesn't mean that the data is missing. It means that it's unreadable. As a matter of fact, one of the things that our expert would do and would suggest is that a process called a checksum be done. I'm going to use some made-up numbers, but let's say there's 5,123 bits or bytes on a particular chip. You can do a checksum and determine that there's 5,123 bits and bytes read now. That means down to the bit or the byte, nothing has been altered, nothing's been changed, and we know that we're dealing with the exact same data set. That checksum would be the first process in doing the additional reading. Then they can go back and use the additional Burla software to see if the data set could be read. After that's done, then my understanding is there would need to be a chip on. They'd need to resolder those specific chips, the 2 micron chips and the expansion chip, back onto the motherboard, install the motherboard back into the truck, and then turn the truck on. That's the process that I understand. My only request is that our expert obviously, given his expertise and his knowledge of this information, he should be there to observe. And the only caveat to that is if he makes a determination, working with Mr. Burgess or observing Mr. Burgess's work, that what's about to happen is destructive to the data on the chips, we would ask gently, and I don't think this is much of an ask, that he be allowed to interpose his objection to moving forward, contact both counsel, both parties, and if need be, present his objections either to us to resolve it or to the court for intervention. That's all. I want the work done, but I want to make sure that the data set that is on those 3 chips or additional chips that are read is never destroyed or in peril of being destroyed. That's all.
All right. Any response, Mr. Brennan?
The defense expert would not be working with Mr. Burgess. He'd be observing Mr. Burgess. The defense expert has no active role in this testing. There is no inherent risk that Mr. Burgess is going to destroy something unnecessarily. This is potentially destructive testing, just as it was the first time.
That's an inherent
Fortunately,
risk.
the information was not destroyed the first time, so we can access it again, but it's potentially destructive testing. The defense is not entitled to veto power during the process. That will delay things. It has no role and no purpose in it. And so, inevitably, Mr. Burgess is well qualified. Mr. Burgess is competent, and he is going to test these chips and provide the information to the defense. They'll get an exact copy. The idea of checksum, there's no mystery to these words. There's a protocol that's followed where they use the old software that was ineffective, and they test to make sure it's the same amount of data that's unreadable. And after they confirm that nothing has been moved or destroyed or tampered with, then they bring in the right programs, the right software, and they'll retest it properly. It will provide the information that will be available to both us and the defense.
All right, so if I act on this motion quickly, because there isn't a basic objection to it being retested, when can they begin, Mr. Brennan?
Your Honor, I spoke to my expert this morning, and I asked him for a schedule when he could test. I told him I'd like it as soon as possible. We didn't finish the conversation. What he told me is December 2nd or 3rd. I told him that would be inadequate. That's too far out. I want it done before Thanksgiving because time is of the essence. And I think it really develops everything else that will happen in this case as far as other experts. So I need to resume my conversation with my expert, encourage him, and insist that we make some changes in schedule. So I can't give an exact date because that conversation wasn't what I was expecting, but I don't think we can tolerate waiting that long.
Okay. All right, this one I will act on very quickly. All right, so I think that just leaves us with the motion to continue. I know it's a joint motion, but I need to hear from both sides as to why I should do that. Mr. Brennan?
January 27th is not good. Why are we going to extend it?
And the request is for an April 1st date. You're not looking to go any further than that, correct?
We are not. We are not.
April Fools.
Your Honor, the Commonwealth has been on this case for some time, and I am newer to the case. I'm not looking for a personal accommodation, but I think the idea of a motion to continue in our joint request is in the interest not only of justice, but I think inevitably, I truly believe it's going to have a more efficient and effective trial. A part of my perspective is to move as quickly as I can, and that's why I've started with the Rule 17 motions. I've also tried to retain as many experts as quickly as possible. The experts will need to do whatever testing they're going to have and conduct, and then I need to provide the reports to the defense. The defense then may have counter-experts in reciprocal discovery that I want well in advance of trial. When I first entered the case, I was committed to January 27th, and I still am. If the court decides that's more appropriate, I will be ready on January 27th. However, I realized when I was trying to move and facilitate the testing of these ships in 2 weeks, and the government, the defense wanted more time, and I appreciated that their request was reasonable, I began to understand that it is going to take a little bit more time than I wanted to have the experts notice, the reports done, and then the defense have time to manage whatever the information is. I do not want to get into a position where we're turning over expert testimony, they're retaining experts to counter that testimony, and then to reciprocate in discovery where days, weeks, are in the midst of trial. I want to avoid unfairness to the defense at all costs, but I also want to avoid any unfairness for the prosecution, and that includes reciprocal discovery. And certainly, the reciprocal discovery cannot happen until I've provided everything that I intend on using. I have tried to exercise extraordinary diligence in this case. In addition to Rule 17s, and in addition to retaining experts, we have brought on my full-time paralegal, and we are going through the entire discovery. And I know it's already been provided, but it wasn't Bates numbers, which I'm accustomed to. And we are re-indexing all the discovery and re-providing it, even though I expect most or all of it has been provided. And I'm doing that out of an abundance of caution, so I can be confident that the defense has every document I have. That will resolve or prevent any delays at trial of inadvertent late disclosure or any concern or confusion about documents that have been provided. I also, with the office, have diligently moved to obtain all Rule 14 statements so that we can get the information to the defense as soon as possible. I've employed a practice when I'm retaining experts. I don't wait until we've done testing or reports. I immediately give the CVs to the defense so they can get started on investigating and looking into the experts. So nothing is held back when I receive it. If I receive any information that is discoverable or frankly not discoverable, I provide it to them. You can see in my discovery notices when I get emails from strangers with theories that I don't even agree to, that I don't know, I don't evaluate it, I give it to the defense. And so we're doing all of this to try to be as efficient as possible to avoid delays at the time of trial. And it will allow me, when I evaluate this case, which I'm still in the process of doing, of reducing the witness list substantially. And so although it does delay the case, if you allow this motion, I think it will make for a shorter, more effective, efficient trial, and I think it will be, importantly, more fair to the parties involved. And that's why I asked you to consider that continuance. I do not expect I would come before you and ask for another continuance. If something cannot get done in time with an expert of my choosing or that I would like, I appreciate I won't be able to use that expert. And so I think the joint request is something that is legitimate. I think it's well thought, and I leave it to Your Honor. Thank you.
All right. Who's going to argue this for the defendant?
I will, Your Honor. I'm not going to belabor the point. I mean, not surprisingly, in a joint motion, I agree with the argument made by Mr. Brennan. You've heard that there will be new Commonwealth experts. There are no reports yet. There have been no disclosures. No forensic testing has yet taken place. And the time frame, according to the motion, is somewhat unclear at this point. Clearly, once testing is complete, disclosures are made, we would have the right to consult with our experts and potentially employ additional experts depending on what the testing
Have you been working on that, though, in anticipation?
We have,
Okay.
yes. Mr. Brennan has promised to index all discovery so that both sides can be satisfied that full disclosures have been made. I know he's been working diligently on that. He needs a little bit more time to take care of that. I would remind the court that during the last trial, we were still receiving reports and some discoverable material as trial was ongoing, sometimes deep into a trial. And we're really trying to avoid that this time. It's really not fair to Ms. Reed that discovery is not complete well in advance of trial so that we can assimilate and incorporate that discovery into what would now be a retrial. And our position is, Your Honor, there's simply not enough time between now and January 27th to get all of that done and properly prepare for trial. And I would just close by saying that both sides and the court have an interest in having this matter proceed to trial expeditiously. But in our view, and I would expect in the court's view, the most important consideration here is Ms. Reed's right to a fair trial. And in light of what's outstanding and what needs to be done, we believe she would not be able to receive a fair trial at the end of January. We're essentially asking for a 2-month delay, which I believe is reasonable in light of what we've already discussed. We do not anticipate any further continuance requests, just like Mr. Brennan said. So we'd ask the court to allow this motion.
All right. What do you anticipate we need to do for in-court hearings? You mentioned in your motion, in the joint motion, a Daubert hearing. How many dates are we talking about? We already need a new date now for Rule 14, for the Rule 17 motions that we have. So we need to start moving forward with all of this. Is there going to be a Daubert hearing, and who is the witness that you anticipate a Daubert hearing on? I'd like to get that on our schedule now.
We have not yet drafted the motion, but I've given it much thought. The government at trial called an expert regarding a dog bite. Forgive me, I haven't watched all of the trial.
No, that's fine.
That expert, I do not believe, followed the proper methodology or had the expertise to make.
All right, does the defense intend to call Dr., I've forgotten her name.
Dr. Russell.
Dr. Russell, do you intend to call her again?
I expect that she will be on our witness list.
All right, so why don't we set a Daubert hearing sometime in December? Does that give you enough time, Mr. Brennan?
It does, Your Honor.
Okay, so why don't we set a Daubert hearing? I know you'll have to fly her in, but why don't we get a date now in December for that?
Does the court anticipate that being a different day than the date we're going to set for the Rule 17
Rule
motion?
17 we're doing as soon as possible. We'll do before that date.
Understood.
This is good stuff. This is going to be a game changer. If they get any data off the additional boards in that car, how are we looking? Seriously, cameraman?
Maybe we can have it filed on the 25th.
Alright, so Mr. McDermott.
May I approach Mr. Brennan for a minute?
Sure. Jim, can you pull up Jimmy? How was it's December 10th? I think we moved both our
If they get any information off the remaining 2 boards, it could just seal this, or they could get information that would cause them to drop the case.
I think we just put something else on this morning that would be time consuming.
Or it could get information that would make Karen want to plead guilty. It's going to be huge
I could
if
also
they
do
get
the
something
12th
off
if
those 2
Mr.
cards.
Brennan's available, and my co-counsel.
I was looking at the 10th, but Jim, could you look at the 13th and 10th?
Yeah, this is the 10th.
The 10th work for both of you? The government's available on the 10th.
So I have a, you cannot do the 10th, okay.
Your Honor, just to be completely candid, I have nothing on the 10th. I've got to fly out on the 11th, and I've got an all-day hearing on the 11th. So I'm sorry, I'm reversing that on the 9th. I didn't fly out on the 9th. And I've got an all-day hearing on the 9th back in California, so I can't fly that day. So
court ends at what time?
I'm sorry, Your Honor?
You can take, a lot of people take a red eye, right? Can you come out then?
I do every time.
You can't fly out on the 9th? The
I
evening
cannot
of the
fly
9th?
out on the 9th. There's no way I can't make a flight on the 9th.
What about the 16th? It's a Monday. Is that?
We're fully booked that Monday and Tuesday.
Okay.
Let's stick on the 13th. Are we still on the 13th?
Sure, if it's available. Jim, we just put Gaston on for that day. Yep, we have a full competency hearing, and we also do on Gaston. About the 12th. Can you just look at that? Did you say the 12th?
The 12th works for me.
There's a little pin. I'm trying to get it to work.
I can do the 12th.
We'll accommodate, yes.
All right, so the Daubert hearing will be December 12th.
That'd be at 9 o'clock, Your Honor?
Yes. All right.
And those motions to be filed on the 27th?
We'll get a date on that in just a minute, Jim. When are you available for the Rule 17 motions? How about November 26th?
I have a trial that morning.
Where?
In Woburn District Court. To the extent that the court would give me a protective order, I can do that.
Or tell them that you have a trial here, and if I need to speak to anybody, I will.
Okay, appreciate that.
Or not a trial here, but this motion hearing.
Okay.
I'd like to do it as soon as possible to get those out and get that moving.
Thank you.
So November 26th, Jim, can we do that in the morning?
Yes.
Okay.
I'm told that Mr. Jackson cannot make the 26th.
For the Rule 17 motions, do you need to be here in person?
If I could have 10 seconds.
It's like, no, it's not going to work. It's not going to work. I got the big game. Don't make him. You know how long I've had tickets. I've had tickets for the big game. Can I zoom in from the stands? Yeah, I guess.
Your Honor, in this moment, if I could just alert the court that there is one additional Rule 17 I'll have filed by Friday. It is similar to a number of...
File it and send notice immediately of the date.
I will.
Okay.
May I inquire, do I send notice on behalf of the Commonwealth, or does the clerk's office send it?
Mr. Lally can inform you on the process, but
Thank you very much.
send it right out. And,
We will.
okay.
Thank you.
Is that okay?
Yes.
Okay. Yeah, we'll make the 26th work.
Great.
I likely will not be here, but she will be represented.
These are third-party records they're asking for.
10 a.m.,
It's
Jimmy?
Rule 17
Get
stuff.
all the record holders who want to be here.
And we're lagging. Let's see if we can.
All right. And all the other motions are taken under advisement.
Great.
Okay. Thank you very much.
Thank you.
All right, so the court, please.
All right. As
Mr. Clerk, whenever you have a minute.
Whenever you have a minute.
You are muted.
All right. So interesting how that went down. The motions, the Rule 17 stuff. We saw the motions before. I think the state was trying to get Karen Reed's dad's cell phone records and say, hey, because there were calls that made back and forth that morning, we want to find that out. We've got some stuff where the state had revealed in an email. Hey, the lawyer just popped up. That's cool. It's an old video. Still thought it was cool. Just autoplays him. There's an old email that came up that basically indicated there was a conversation that the prosecutors had with one of their witnesses, and the message or the contents of that message was such that it had not been disclosed, and it probably should have been disclosed. And so the defense basically said, hey, we want that message, officially, we want that communication and any other communication you've had with any other witnesses. Sometimes these out of, proper, proper interview scenario discussions are more insightful than the ones that happen during the actual deposition. So they want all those. Those are being turned over. This prosecutor's all about turning over. He's like, I'm doing it. Every time I get an email, talk about the wrong thing to say on national television. Every time I get an email from any stranger with some wackadoodle theory of what actually happened that night, he forwards it to the defense. If he wasn't just asking for spam, I don't know what he was. But yeah, so that wastes both the defense time and the prosecutor's time. Please don't send wackadoodle theories of what happened to the prosecutor, because it gives everyone more work, and it probably is not useful. But the big thing that comes out of this one is the state wants to retest the boards, the chips inside the Lexus. It was a Lexus, right? I think it was a Lexus. And see if they can find more data. Maybe positional data, maybe like literal GPS data, trip data, history. Apparently they only tested one of the 3 boards. And I think they got all the data from what I've read. I think they got all the data off that one board. But remember, the information was like weird. It's like, this is the percentage of distance that the gas pedal has been pressed at a certain time. And it's good information. They could build a theory around it, but it was very incomplete. And they had no location information. The timestamps were a little skewy, and how it records is weird. If there are 2 more boards inside that navigation system with more chips on them and more data, it could be a game changer. And this is very fortunate for the state. First of all, they got a chance to redo this, because I don't think anyone will question or will squibble with the is squibble a word? I think I just used it incorrectly. With the notion that the state sort of screwed up this investigation the first time around, that they took some shortcuts where they shouldn't have been shortcuts, that ended up burning them and a little bit in court. Because of that, they squabble. It's you say potato, I say potato, right? Anyway, they got burned a little bit. They had some experts who I think were not experts. You can remember the different witnesses that were on the stand who knew nothing about math and knew nothing about the science of the field in which they claim to be an expert in. They get a redo. And whether it's right or it's wrong, the way everything's shaken out is they get a redo, and the state can come in with new evidence, and they are. That it's not appropriate to just spring it on Karen Read at the last minute. Trial starts January 27th. Here we go. By the way, we got all this information off your Lexus console, and good luck defending it. That's not fair. So there's a delay. The delay is so that the information can be extracted. It can be analyzed by the experts on the prosecution side. Then those reports can be turned over to defense. Defense has their own experts. They will analyze the data and maybe find either, different information or something else from that. But it'll give them time. And this extension into April 1st, so an April Fool's Day start, if that isn't just like perfect for this case, I don't know what is. That's going to give them time. But the information they find, this might blow up the case even before we get to April 1st. Because look at this. If they have data that literally shows, they pull this other data and it shows the last trips the car made, and it backs up and goes forward and everything, and ramming speed, whatever they find impacts this happened at this time. It might be on there. There might be that sort of information on there: trip data, times, GPS locations. It may also find that some of the sworn statements the officers made under oath about where that vehicle was and when are not true. That it may have driven places when it shouldn't have been driven places. It might find all sorts of stuff because it records everything when it was running, everything. So this is risky for the state to do, and I think it's also the right thing for the state to do because this could be exculpatory evidence that's in there. It could be very damning evidence, but either way, it will be the star of the show this next time around because this is the only new little piece we have in this case. My nerd is showing this discussion. It is. I don't like how this went down. I don't like that Karen Read is facing the same 3 charges. Again, I think it was poor handling on the judge's part with the jury. I think the jury instructions were confusing. I was on board with the defense when they objected initially, when they didn't like what was going down. I don't like how it ended in a mistrial. I think I would be perfectly fine with her just facing charges, just facing 1 of the 3 charges, not the 2 that the jury agreed on. That would be good. That would feel good with that. Fortunately, it's working through the system. I think the Supreme Court still has a decision yet to make on that, right? I don't think they've ruled. If they have, it's going back to trial. And, if the law is bad, you have to change the law. But currently it looks like she's going to be tried again and the double jeopardy does not apply. Anyway, just a crazy case that's going to get absolutely wilder. And I love the prosecution. This new special prosecutor, Mr. Brennan, is just on it. He's smart. He walks in. He's like, first of all, the organization on this case is terrible. I'm reorganizing everything. Nothing's been bait stamped. I'm used to this being professional. It's as close as I've seen a prosecutor come to throw a former prosecutor under the bus and say, Mr. Lally screwed this one up 6 ways from Sunday, and he's gonna make it a little bit better. It helps the defense. It helps the prosecution. It's going to be a cleaner case because of this, a cleaner trial. And yeah, I will definitely watch it for this reason, just for this little piece of information, which may end everything before we even get to April 1st. Because you've got the prosecution already has a theory, right? They might change it a little bit, and they can come in with a different theory on round 2. They can say it happened this way, and it's different than how we say it happened the first trial. That's fine. They're allowed to do that. But whatever is on those chips, if they're able to extract it and it's, pertinent information to this case, if it doesn't match that second theory, they have no case. They have no case. They can't say something happened when there's empirical data that says otherwise. So it's going to be crazy. Wild. All right. That was good fun. I'm glad we got to catch that. Let's see. We can't go there. Hang on one second. I need to unsubscribe to this channel because Disciplinary Board does not like their stuff being shown. I don't want to see their notices anymore. Unsubscribe. Yeah. Got a new letter, though, to frame. That's pretty cool. They wrote me a letter. I don't know if the feds are going to come in and make a bunch of arrests. I think that's an outlying. Yeah, we wouldn't be delayed the second time around. We wouldn't be delayed. We'd be live. And we might, we may send somebody up there. We're working on a couple things. It's assuming Trooper Paul took the chips off correctly and did not damage them or the multi-layer boards they're on. Yeah, it's a big assumption. The first chip was not damaged, so hopefully the other ones aren't as well. I'm not sure if Chris and Aaron want to travel up to Massachusetts for a couple of weeks to Canton. I don't know. That it's going to be an expensive one, so we have to look and see if we want to proceed, or how we want to proceed there. Been in public, says Melissa. I've been in public and heard strangers talk about this case, and I've turned around and asked them if they follow true crime, and they all say no. Then how do you know about the case? Just hear it on the news? Must have missed it. What chips? There were 2 more boards inside that Lexus console in the navigation system. There are 2 more boards with chips on them that should have retained data, trip histories. GPS data possibly might be on there. All the data that we didn't get on the first chip. OG Sean White. I'm looking for someone who could commit to being there in court before every day and being there plugging in equipment and running it live. We might talk. Patricia, why wait for an official South Carolina ruling before proceeding? Or Supreme Court ruling before proceeding, if the off chance they rule in her favor, all this prep was for naught. True, right? But they also have laws that if they are retrying, they have to proceed on a set schedule. They can't just wait. You can't just hold the case forever. They have to proceed as if it's not a problem. So the proceedings are not on hold while the Supreme Court decides. If they waited, then it could be a violation of other rules in the state about retrying and how fast it has to go. Lally was off the case. No Lally today, and what a relief it was. It was like the old plop plop fizz fizz. Oh, what a relief it is. No Lally on this case. Do you guys remember that commercial? I'm not sure why that came to mind. I think it was the Alka-Seltzer commercial. I think they should bring that commercial back. That's sort of one of those timeless commercials that just sticks with you. He was in the courtroom at the prosecutor's table. He's writing second chair. Okay, so as long as he doesn't talk, I'm good. I did not even see him stand up one time. He was there with his head down on the table, taking the beating which he so justly deserved. Let's see. I'll have to go back and look. I did not even see him. Did not even. It's like my eyes blurred him out. Broken. Okay, you and I are old. I remember too many of the old jingles. Let's talk sooner than later. I'm willing to take a vacation time to help you out. It's a long case. It's a long case. And basically with Sarah Boone, what we had with Sarah Boone, Chris from Trial TV Live was at court every day about 5:45 in the morning for the duration of court until after it ended, with equipment running it the entire time. That's what we're looking for. And if you're not there, we miss the connection. We can't. It's not something you can leave set up. It requires a lot of oversight. Speaking of oversight, AZDCS Oversight Group says chips and tracking in vehicles is why I prefer my 63 Volkswagen Bug. 63. That's like Herbie style, right? Those are the good years. We may cut out 30 witnesses the second time. I think we can cut out the first half of the trial. Let me prove other people not guilty part. I think we can cut that out. Amber. After he forgets means like it's like a forgotten or a foregone conclusion. See what I did there? Oh, slug bugs. I still have bruising on my shoulder from slug bugs. I wanted to go back to Oakley. I'm not sure when we get the pro se guy, the sov sit. Judge Middleton's live. Somewhere Judge Webster's live as well. Let's see. Let's go back to Judge Oakley just real quick and see if we can find when we get that sov sit. Judge is checking his phone, see if he still has the Candy Crush high score, which he does.
So, Ayden, please testify right now.
Mohammed and Mr. Jones being short, Judge.
Oh, so he's here.
Yes.
Is Miss Conrad, she has two Carson.
I don't know.
I just talked about.
What is it, Carson?
We hear on
Carson.
Carson and Olson.
I got both files, counsel, so pick one and give me your appearance.
We can do Teresa Carson.
Got it.
Neighborhood Defender Service by Sarah Khan, P86948, on behalf of Miss Carson, who appears via Zoom. Miss Carson, would you please unmute and state your name for the record?
You're muted, Miss Carson.
You're still muted. There should be a microphone button at the bottom of your screen.
What's Jonathan's?
There we go. How's that?
Good.
We can hear
Go
you.
ahead,
Could
counsel.
you state your name?
Teresa Carson.
Thank you.
Thank you.
You're welcome.
Your Honor, I'm requesting an adjournment on Miss Carson, and I would also like to submit a discovery order to be signed by the court. I still haven't received, Miss Carson was before 34th District Court last week. I still don't have paper discovery, and I also asked for digital discovery. The APA indicated that the OIC had requested for digital, but still hasn't heard back. I would ask for an adjournment and for the court to sign that discovery order.
Pick a Wednesday.
Any Wednesday will do. As long as it's this year.
Your Honor, unfortunately, my am out of town a fair amount. I could do the 20th, which is next week, or I could do January 1st.
Let's try next week. What's that, Ms. Carson?
On the 20th, because I've got another court case I'm taking care of. I'm trying to take care of all this because I'm almost 61. I'm way too old for all this. Yeah, on the 20th, we have another date. So if I can't do it November.
What time is your case on the 20th?
It's an in-person in Saline, and transportation is a problem for me because I'm way out in the country.
The question was, what time was it, not where or what your transportation problem was.
It's at 11 o'clock.
11 o'clock?
In Ann Arbor, yes.
Okay. I don't know why we couldn't do this one next Wednesday morning. We're going to do it by Zoom.
Oh, if it's by Zoom, yeah, I can do it by Zoom.
Counsel, does that work for you?
That works for me.
All right, let's do it 11:20, 10 o'clock. Does that work for you, Ms. Carson, 10 o'clock next week?
Yes, sir, that'd be great. On Zoom, yes.
And the prosecutor you're talking to on this one, counsel, I'm assuming that's Mr. Mohammed?
Yes, that is.
All right, we'll make sure he knows he's got a 1 week schedule to get some discovery.
Okay, thank you.
Carson, have a nice day.
Thank you. Have a good day.
Are you also ready on Olson now?
Yes, I am.
Miss Olson, unmute. Go ahead, counsel.
Good morning, Your Honor and Court Staff. Neighborhood Defender Service by Sarah Khan, P86948, on behalf of Miss Alicia Olson, who appears via Zoom. Miss Olson, would you please state your name for the record?
Alicia Olson.
Good morning, Your Honor. For this case, I'm also asking for a brief adjournment so that Miss Olson can make an informed decision about whether or not to take the plea that is offered. If we could also come back on the 20th, that would work.
Sure. Miss Olson, next Wednesday, 10 a.m.?
That works, thank you.
All right, your bond is continued. We'll see you next Wednesday.
Thank you.
You're welcome. Have a good day, counsel.
Thank you. You as well.
Sure.
So, Mr. Cohen. Mr. Cohen or Mr. Martin?
Hi, good morning.
Who's hearing for Ms. Cho?
Both of us, essentially. Either of us.
Okay, so who wants to break out room with the defendant?
Does Mr. Mato speak English?
Yes.
Yes.
Yeah. Okay. Just wanted to make sure. Jonathan, I can handle it. I'm sitting right. You're in your car. I'm at home. All right. Thanks, Gary. Yeah.
Thanks, guys.
Yep.
Mr. Jones, are you ready on Disney?
It's like the lawyer version of ambulance chasing.
Okay.
For public defenders cases.
Hey, you're so right. How are you? Everything good?
Good. Are you Mr. Disney? Come on up.
Sit with me here. I'll be in a second.
Make yourself comfy, Mr. Attorney. Just plop your butt down there on the table. It's a casual court.
You're good. Thank you. No, that's
The only way to state exam.
Well, unless it's a special prosecutor, we can usually do something else, but it's hard to do it with our regular prosecutors.
If I can say two things to be true.
That's true. Yeah, maybe. That's what we can talk about.
Oh.
He's got to convince me.
It's also to get off the courtroom furniture. You know you're comfortable in court when you can just take a seat wherever.
Are you in session next week?
I feel like
Is it any worse than any other day?
It's probably about like today.
He was looking for one case, he was looking for the paper docket. It was like he was telling for a week.
he's sitting in the spotlight on the desk. Rays of sunshine just lighting him up in court. I think it came free with 2 other suits.
Extra copy of Van,
Yes.
Mr. Kelly.
There's the. I said the same
You
thing
mean
at the same
you
time.
can't find the defendant?
Yeah, well, I'm texting Pravanchi now because he's in custody and
They can't find him.
well, he's not here. So I'm texting him and asking him where he's at.
Can't find an in custody defendant. That is a significant problem. You might want to call in a police officer who has a bloodhound. We got a
Hey, Joe, can you check on Hairston? And I'm going to pronounce it Roulette, R-I-L-E-T-T, the last 2 probable cause hearings we got scheduled.
What time is it, Judge?
Hairston at 10:30 and 10:45 is Roulette. Leonard Roulette.
I have Harrison.
Showing is here.
No, I don't know. Check.
I like a comfortable lawyer in the courtroom. But this level of comfort shows that he might have a sort of relationship with the judge that could benefit the defendant. Don't think this judge.
All right, gentlemen, your appearance is on the David Disney file.
Good morning, Your Honor. Mohammed on behalf of the people, PA 6771.
Good morning to you, staff, and brother counsel, Jonathan Jones, opinion of Mr. Disney is over my left shoulder. Judge, we're set for exam today. Bluntly, I didn't anticipate this would go. The complainants reached out to my client to let them know that they weren't coming. As such, I expected it would be dismissed. Brother counsel wants to hold. I have evidence. I need to prepare it. I simply didn't bring. I'm asking for a week.
Judge, I'm ready to hold. This exam has been scheduled. People are ready, and we're ready to move forward. I understand the defense's request, but I just,
Do you have any civilian
I've had situations where I appeared and forgot papers and I had to move forward. I don't have my victims here, but I'm still able to move forward.
So my question is, do you have any civilian witnesses?
No civilian witnesses are present for today's hearing.
Do you have any problems with availability of witnesses if we adjourn it 1 week? And I know you don't know that without asking.
Are you able to be here next week?
Yeah. Is he the only one we need?
There's one other gentleman here.
There's another Officer McGregor, but I don't anticipate I'll need him to move forward. I'm unsure. Yeah, I should be able to move forward next week.
I'll give a 1 week adjournment.
What? Is allowed.
I don't know the schedule for next week.
What's the question?
Is 11 okay?
Probably not.
Probably every time pieces. Whatever.
You're probably going to be a little bit later in the afternoon.
I can hear 1:30 if you want.
1:30 is a good time.
All right, let's just go to one. Is that?
All right.
All right, thanks for understanding. Thanks, Chair. All right.
I'd like to address bond, but
Go ahead. Well, hold on a minute. Let me make sure we're all on the same page. According to what I'm looking at on our register of action, it's 5,000, 10% with tether and no contact.
Correct.
We all agree that's what it is now?
Sounds like domestic of some sort.
I wasn't aware it was on a GPS tether, but if it is,
I know that's what the bond was required. I'm not sure. Are you on a tether? Yeah. Okay.
is there permission to leave the location? I believe, based off whatever view, the defendant should be on house arrest.
That wasn't my understanding.
There's nothing on the bond to that effect. It says he can't return to the address on e-course.
He hasn't.
Does that satisfy people's concerns?
Yes, no, so Judge, I'd like to still address bond and request the defendant be placed on house arrest at his residence, obviously not the one at the location where this crime occurred. I believe the defendant.
Let me stop you. I got you currently on Fort Street in Rockwood. Okay, go ahead.
I believe this defendant poses a serious danger, not just to his parents, the victims in this case, but the public at large. The facts in this case are extremely disturbing. And from what I recall is, he walked into their room while they were sleeping, started assaulting them, involved a shotgun. Statements were made about killing them. I think anyone that has the guts to do something of that nature is a serious danger. I don't think that's normal. I think it's extremely concerning, and I worry for the public at large. And if he's going to be allowed to roam the streets, I believe the way to address that is for him to be on house arrest. Shouldn't have the privilege of roaming the public with things of that nature. Furthermore, I think he's a habitual offender, if I recall correctly. And this isn't committing a crime isn't a one-time incident where something that just happened. It seems to be a reoccurring theme.
Well, I got to cut you off though. First of all, let's not forget that at this point in time, he's accused of committing this crime.
Correct.
Secondly, those are all good arguments for initial bond hearing. This is 2 months after the bond was set. Has there been any problem since September 18th? Is there any?
Not that I'm aware of.
I'm going to leave the bond as it is. All right, gentlemen, next week. We got anything ready?
Your Honor, I'm ready to go on Mr. Motto.
On what?
Motto.
Motto?
He might still be.
Hold on. They're talking to me on Zoom and everything else. Let me get Zoom out of the way and then we'll get you two go. What are the two names, defendants?
Green and Harrison.
Green and Harrison? Appearance for Motto.
Just wanting to make sure that we brought him out of the breakout room. Yes, seeing Mr. Motto now. Good morning, Judge Oakley, and to your staff, Neighborhood Defender Service, Carrie Martin, P84592, appearing on behalf of Mr. Shanil De Motto, who appears by Zoom from the Wayne County Jail. Mr. Motto, please state your full name.
Shanil De Lewis Motto.
Thank you. Go ahead, counsel.
Your Honor, I believe we will need an exam date set today, but mostly I want to address Mr. Motto's bond.
All right, I've got to get the prosecutor in here so he can have some input.
Okay.
Joe, just ask him if he wants input. Tell him it's currently 30,000, 10%. I'm inclined to a personal unless he's got a good argument.
Yeah, he's going to come in.
Counsel, let's look at calendar dates. I'm available next Wednesday, December 23rd and December 30.
Let me check because I'm standing in for my colleague Alexandra Choate.
So take your time.
Check her calendar. What those dates one more time, Judge?
Next Wednesday, the 23rd of December, which is not a Wednesday, it's a Monday, and then the 30th.
The 30th of December.
Correct.
Right. Okay. So December 30 or December 23
or November 20
or November 20. Let's take December 30.
Setting an exam, Mr. Mohammed. Let's do it at 11 a.m.
Perfect.
All right, let's talk bond. Currently, I think it's $30,000, 10% with no conditions.
And Your Honor, I can go ahead, Mohammed.
Go ahead.
Yeah, Your Honor, we would be asking that this be reduced to a personal bond. Mr. Motto has been held for more than 2 weeks on these matters, which are nonviolent matters. I don't see any violent criminal history from Mr. Motto, nor have I seen any indications that he poses a flight risk. This is a failure to return a rental car case. And I did confirm stable address and phone number for Mr. Motto. He lives in Pontiac with his wife, with their 2 young kids. Both he and his wife work at the Popeyes restaurant on Telegraph. She's a manager, he's a chef, and it's just been really hard for them with him in custody. Sounds like he really needs to get home to his family and keep making money to pay the bills.
Thank you. Mr. Muhammad.
Judge, people would object. I don't see a change in circumstances since when bond was initially set. And furthermore, from my recollection, I had a prior conviction for an OWI, and based off of his history, the reoccurring themes of criminal cases, people would object. I think he does pose a danger to the public. That's the people's position.
Okay, what's his danger?
Driving under the influence and taking the roads.
When was that?
What's that?
When was his conviction for it?
The docket or the documents in front of me, but I do recall reviewing it and seeing what of the violence criminal.
Okay, fair enough.
If I recall correctly, his criminal history was 70 pages long. I don't think there were all convictions. And from what I recall, I do remember seeing the OWI. I don't know if other stuff is work. But that stuck out to me because 70 pages is really long, but I don't think they're all convictions.
Okay, fair enough. Mr. Martin, anything to
add? Only want to add that Mr. Mato cannot post this $3,000 bond. He cannot afford it. Really, money is so tight for him and his young family that any amount of cash bond is an unaffordable bond for him. And I don't have any information about an OWI. I can't confirm what Mr. Muhammad is saying.
Yeah, and unlike the old days, I don't have a CCH in the file. Oh, yes, I do. Yeah, he had, out of the 45th District Court in 2019, he had operating while intoxicated dismissed. Operating impaired out of 44th. Are you on probation at the 44th District Court, Mr. Mato?
No, the OWI was dismissed, Your Honor.
No, that was the one from the 45th District Court in 2019. I'm talking about an October 2024 arrest. Says you pled guilty. Oh, and you were given jail time.
Yes, sir. Yes, Your Honor.
Is that what you're in custody on now?
No.
I don't think so.
Okay, and I've got like a 3 or 4 pager, so I'm not sure what you.
Again, I don't think it was criminal conviction.
Yeah.
I just remember it stood out.
All right.
This is Romulus District.
All right, Mr.
Court.
Mato, I'm going to give you a break. I'm going to get you out on a personal bond.
Detroitish.
Mr. Martin, I'm assuming you're going to be communicating with the gentleman?
Yes, either me or Attorney Choate from my office, and I will keep her.
He needs to contact Avery Taylor at our court, and he can do that on our website because he's not driving in from Pontiac. Mr. Taylor's got really good resources with the social services agencies in our area that might be able to help get him and his family over the hump. Now that he's been out of work for 2 weeks. Thank you, Mr. Muhammad.
Thank you.
All right. So, sir, I'm going to put you on a personal bond. The first condition is the obvious one. You stay out of trouble. The second one is almost as obvious. You got to be here for your court date on December 30. In the meantime, raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $30,000 if you screw this bond up?
Yes, Your Honor.
So you're on a personal bond. If you screw up, you're going back in custody, and it's going to cost you $30,000 to get out. No 10%.
I understand, Your Honor.
All right. Good luck. Thank you for jumping in on this one, counsel.
Thank you, Judge Oakley. Nice to see you. Have a nice rest of your day.
Thank you. You too. So we're done with the jail now.
Yes, jail is.
There's 2 waivers.
The Cody's?
Yeah.
All right, gentlemen, your appearances on Green and Harrison.
Good morning, Your Honor. Mohammed on behalf of the people. PA 771.
Good morning, Your Honor. James Anderson, P 31302 on behalf of Aaron Harrison. Good morning.
Good morning, Your Honor. Spencer Clinton, appearing on behalf of Mr. Green.
Thank you. All right, you folks have talked to your attorneys. You understand your rights and options? All right, you both understand what the purpose for a preliminary exam is?
Yes.
You understand if you waive the exam, we're going to give you a court date, so the next step is downtown, circuit court level, not district court where we're at today. Understanding all that, are you waiving your exam freely and voluntarily? You same, freely and voluntarily? Gentlemen, you satisfied with the waiver?
Yes, I am, Your Honor.
All right. AOI date's going to be 2 weeks out, 9 a.m. I've got signatures I need from all 4 of you when I'm done with the files.
Next step is downtown.
It's supposed to be from the jail. Provided to me to call transport. It's at 2 o'clock. Do we want to try to get it done?
Who's attorney on that one?
The attorney. Nancy Richards.
Is Mohammed the prosecutor?
No, Patricia Manning.
Let's get some input from her. Get Mandarich in here while I scribble files. You're fine where you're at.
Okay.
Oh, what's the
Kevin Kelly.
Kevin Kelly?
Yes.
He's still at the jail. Do you think that's going to go? We'll transport him out. If you don't think yours is going to go, we probably won't put him on the road right now.
I don't think it's gonna go, and I can approach the court and discuss with the defense counsel, so there's no ex parte communication.
Is she here?
I don't believe it. I haven't seen Ms. Richards.
Okay.
Do you want me to have Ms. Richards join on Zoom?
See if she can do that. Will that work?
Yes, if the court will just give me maybe.
Yeah. I'd rather not put him on the road, just bring him out here if it's not going to happen.
Before we go to lunch, I'm going to do a little recap of what's coming up starting on Friday here with a new case that we're starting on Friday morning.
Okay. Joe, one ready for signatures. I'm done with it.
Sign here, 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 and here. Apparently there are individuals who travel the Michigan Circuit of Courts and
what do you got?
I'd like to visit.
Carlos Fisher, Your Honor.
Visit some of the notable YouTube celebrity judges.
Thanks, Judge.
Thanks, guys. What's the name?
Last name's Fisher. First name Carlo. Officer Kroba may have pulled.
He did.
We didn't have a form filled out, so I went ahead and just.
Yeah, that's all right.
I did pull it. I said.
I got it.
I'm screwing up your operations.
No, we're good. Your appearance for Mr. Fisher.
Good morning, Your Honor. To the judge, on behalf of the defendant, Carlos Fisher, Mr. Fisher, statement for the record.
Carlos Fisher.
So, Your Honor, I'm in, there's been a tremendous amount of pretrial back and forth today trying to work through resolutions. There have been several plea offers made. At this point in time, we're going to be setting matter for a jury trial. I think there is a little bit of outstanding discovery on this matter. And I'll defer to the people. There may be some other issues. Before we wrap this one today, if I could address a no contact. This individual.
Let's hold off. Let's get the.
So I don't forget.
You got jury trial dates for Patricia?
No, we're going to one to next year.
So a TBD?
Yeah.
All right. So we still don't have our 25 calendar set. So Heather will reach out to both you and Madam Prosecutor and pick a date sometime after Jan 1.
I've advised Mr. Fisher that just speculating that we probably would not be before mid to late February based on the amount of trials that I think are already coming, but
I wouldn't even guess. All right, so currently the bond is 5,000 PR, no contact with complainant, and can't return to the Swan Lake Drive address. Agreed? That's the current bond? All right, go ahead.
So, Your Honor, we're not actually asking for any modification as to bond at this time. I've advised Mr. Fisher that he's receiving medicine. He's
okay.
Currently right now going through dialysis. I think 3 weeks, you said?
Monday, Wednesday, Friday.
Monday, Wednesday, Friday. He does have medicine that's been arriving in the mail. So I believe that the people are going to work with the complainant in this matter to get whatever may have been collected, both old mail, old medicine.
Okay.
We'll work out arrangements.
Civil standby.
So I think we're going to do that.
Well, not to cut you off, but I am going to stipulate, Judge, to one civil standby so that defendant can collect his any mail, any medication, which complaining witness indicated she has portioned out.
Okay.
Spare keys.
Okay.
the mailbox. However, we have, and the Idaho Defense Counsel has indicated she found that the defendant needs a new prevailing address. We just can't keep like delivering.
Right. That's fair. That's fair.
Mr. Bishop should advise, go to the post office and then either stop him so he can pick it up there or have alternate address. Practically speaking, Mr. Fish will update the court with a new address. This isn't a complainant and a defendant who are married.
Right.
He has nowhere else to go. He's on dialysis. He's pretty well depleted all of his available assets at this point in time and is still paying all the marital expenses, is my understanding, or the majority of the marital expenses. I advise him to update the court. He may have to go stay with family or something during the pendency of this.
Right.
I would just ask, there has been one civil standby already. So had it gone perfectly, probably wouldn't need to be a second one. So as it relates to the keys that we specifically identified, the medicine and the mail, you can just ask them if those items specifically be organized, put together in advance so the officers aren't there mediating it.
Yep, they're ready to go. Okay, all right. Have you put him in touch with Mr. Taylor?
We talked about this already. And actually, I approached the court, full disclosure, without discussing the merits of the case, I was just asking what available resources there may be in the community.
Yes.
I'm going to get him in contact with Mr. Taylor.
Okay. All right. Anything else, folks?
Judge, yes, I did. Like defense counsel indicated, we've had extensive back and forth trying to hammer out the plea agreement in this case. The plea offer that was conveyed today was that defendant would plead guilty to count 1, domestic violence, second offense. And it can't permissibly, the people agree to, they agreed that separate case stemming from Romulus incident, police department incident report number 240000712 regarding an incident on January 14th, 2024 involving the same incoming witness. The charge in that case will likely be another second. Will not be filed. Defendant would be sentenced to 1 year probation, no contact with Stacy Fisher. Defendant may not appear at Stacy Fisher's residence. Defendant must complete batteries and prevention. And defendant may not purchase or possess a firearm. I cannot guarantee that plea will be open.
All right. You understand that, sir? That might not be an offer down the road. Okay. All right.
And, finally, Your Honor, I'd just like to bring the court's attention, complaining witnesses present today in court. I believe she was present here last week as well.
Thank you.
Your Honor, we've waived complaints appearances at today's pretrial and the future ones. We understand she has every right to be here. I think that this may be the right opportunity to address. They do have children in common. I believe that some of them are in possessions of vehicles that are titled to this individual. Again, financially, it's been crippled by this. He can't reach out to the complainant to address this, but I don't really have a great tool in my toolbox to let them know that they're headed towards rocky waters financially as a family as a whole. So if they can speak through the victim's rights advocate, maybe, I don't know, not him and the complainant, but there's going to be unfortunate surprises, I believe, financially coming to the family as a whole that they're not all aware of because of the communication.
And Judge, would you like me to respond?
Sure.
Judge, as defense counsel previously indicated, we have worked extensively to try to hammer something out. I do not want, it's not appropriate, obviously, for defendants to try to stay contact complaining witness.
Right.
Victim advocate. The no contact order is no contact order. It's my understanding that the party's child is 19 years old. She is an adult. I am sympathetic to defendants' position. However, I believe obviously the division of marital property belongs under the jurisdiction of the family division of the circuit court.
Yeah, I'm not dividing property. I don't think that's what's being suggested.
No, but you will be executing writs for seizures of said property down the road if these bills aren't continuing to be paid. So I'm not trying to threaten anybody. I'm just simply getting a fair warning of troubled waters ahead because of the financial constraints that this.
So I'm assuming the daughter is driving one of his vehicles. That's one of the concerns, and he might not be able to keep making payments on it.
Correct. And I know also a daughter who's a complainant or is one of the witnesses in one of these cases, or in this instance case.
So
I know he technically can contact her, but my advice would be not to.
Here's my suggestion. I don't think it's going to cause any problems if he forwards copies of certain notices he might be receiving to the daughter so she knows what's going on financially.
Fair.
That's no personal communication. I got a notice from the bank and I'm just sending a copy to you. Because, yeah, I don't think surprises are good for anybody.
Thank you.
Anything else?
Not for the defendant. We'll wait to hear from the court staff on a trial date. All
right.
Try to get this all scheduled.
Good luck, everyone.
Thank you, Your Honor.
All right. Before we go to lunch, let me do a little recap of what's starting on Friday. We have our new case, the Jose Ibarra case. And let me break this down a little bit. The case is about. Let me go full screen on this. This girl right here. She was Laken Riley. That's who this is. She was a 22-year-old student at I believe it was Augusta University, a nursing student. And where it starts with involving Jose is a morning about earlier this year. It was like 8 months ago, right? I have to double check the date. Somebody was seen peering into her window, and then she went out for a run and she never returned. Her roommates reported her missing, and they found her fairly quickly. Had been deceased, had been attacked and deceased. Jose Ibarra is it's Pickles, not politics, but these are the facts of the case. He was in the country without permission. He and his wife entered the country around El Paso, ended up moving up to New York area for a while. He had some previous run-ins with the law. The first one, I believe, was a simple child endangerment situation where he was delivering food on a moped with his 5-year-old son on the motorcycle, neither wearing helmets. I think he also had another run-in with at a Walmart. I think a shoplifting charge at a Walmart. So there's our tie-in to the Walmart, as there always is a tie-in to Walmart with all these cases.
In front of the Walmart.
So that was pending, and then this happened. He has been fighting in motions as late as this last week to keep evidence from coming into court. Evidence about fingerprints, his fingerprints on her phone, DNA evidence under fingernails, things like that. Key bits of evidence that they attacked the method of collection. They attacked the warrant and how it was written. They tried everything to keep it out, and when they failed on every front on that in front of the judge on these motions in limine to keep these out. Once they failed and this was going to proceed with a jury trial, he then made the last motion that he had in court, and that was just the other day, where he said, I'm waiving my right to a jury trial. I'd like a bench trial, meaning the judge is also the jury. No jury would be seated, no juries impaneled. The judge would hear the evidence, the judge rules on the case, and decides the verdict. He chose that probably because the evidence that comes in would be pretty hard for the jury to hear, and pretty hard for the jury to separate their feelings emotionally from their feelings factually. The judge might be better suited for that. That's at least the gamble that he's taking. I am still wondering if he's going to plead guilty before we go any further. It might happen. So, but currently it's slated to start Friday morning at 9 a.m. So we've got 2 days before that starts, and it's going to be a crazy case. It's going to be crazy, but it's out of Georgia. Let's see. Walmart thing is crazy, but so true. I never go there alone. It has been rare. It's been very rare when Walmart is not mentioned in a trial. Maybe they should be a sponsor on the program. Charged with malice murder. Thank you, Sharon, for this. Malice murder, felony murder, kidnapping, aggravated assault with intent to rape, aggravated battery, hindering a person making an emergency call, tampering with evidence, and peeping Tom. Those are the charges that Jose Ibarra is facing. And it's going to be a good one. He does not speak English, or at least does not communicate proficiently enough in English to understand the proceedings. And so he will have a translator beside him, and he'll be wearing headphones. The translator is talking into one of those Darth Vader masks that the court reporters sometimes wear, where they're like, that's how he's going to hear court through the translator. His part in trial is fairly minimal. There will be a couple points where the judge will ask him questions directly, and he'll have to answer through the translator, but mostly he'll be listening. So when we see him, we'll see him with a translator And luckily, it won't be distracting. We won't hear that noise from the translator. It will just be him. Reverend Beasy, thank you very much. I'm glad people were able to help you out with the puppy list. Maybe Walmart should have their own booth at CrimeCon. Just saying. Interpreter. I'm sorry. I'd rather be day working. Thank you for this correction. The translator is interpreter is the proper term. The interpreter translates the language live. Yes. And I'd rather be day working knows, because that's the business they work in. Good to have you here, by the way. Day working. Tell your boss I said hi. Or coworker. I don't know. Is it boss? Is it boss? Anyway, that's the recap. We're excited to start a trial. We've had about a week's downtime with a little bit of between trials. He's in a meeting now. Thanks for covering for him. We might have to get you a wrench, just like a part-time wrench, just to do his work when he's gone. All right. Video from Walmart. It's also very good. They have a lot of cameras. Because, surprise, surprise, Walmart does not like being stolen from. They are not a big fan of that. It's probably their largest loss item is through theft. It's not through spoilage of stuff that gets broken in the store, or fruits or whatever that get damaged, or Walmart delivery trucks that crash and overturn and burn. None of that happens. Hey, guess what's happening? Hello? Hello?
Hello?
Is this Mary?
Hi, this is Mary from
Mary.
Med Health Center.
How are you doing, Mary?
I'm calling to let
Thank
you
you
know
for
that
calling
after
me.
this recent open enrollment, if you have Medicare Part A and B, you're eligible for great newly added benefits like monthly $180
What year was I
cash
born?
back,
Quick.
dental, hearing,
Spit in
vision,
chat.
prescription
Tell me
coverages,
how old
and
I am
food
and the year I
cards
was
at
born.
absolutely no cost. So, do you have Medicare Part A and B?
I have those. Hello? I have them. The computer was waiting for a yes. I don't like giving yeses to those calls. 1957 and 67. It's good to know. Next time, it's a bot, but if I can get past the bot, there's a real person. And last time I got stumped on how old I would be. I'm sure their theft has went sky high since they went to self-checkout. My local store was self-checkout, and then they completely reworked it after just a couple months. They changed it completely. And I think we're back with checkers again. Oh, they're calling back. Hello? Hello? Hello?
Hi, Dwayne.
Yes. Hello?
This is Amber, and I work in the fulfillment department here at World Class Travel. How are you?
I'm doing great, Amber. How about you?
I'm doing great also, thank you. By the way, Dwayne, I'm calling you in regards to a large amount of travel credit you have on file with us.
Okay.
My job is to close out all expired accounts, but when I saw how much credit you had available, I wanted to touch base with you because I know that you do still see yourself traveling in the future, right?
I'd like to travel.
Good to know that. So, Dwayne, the first thing we need to cover here is this package is good for a lifetime. Even if it takes you 6 months or 6 years to travel, you can. Also, transfer fees are waived. So, to start you off, you will receive a 5-day, 4-night stay in Las Vegas. In Vegas, you will have the option of staying on or off the strip. Next, you will get a 5-day, 4-night stay in Orlando, Florida. In Orlando, you will be walking distance from all the major theme parks. And you will also get a 6-day, 5-night flex cruise, and that's with Royal Caribbean, Norwegian, or the Carnival Cruise Line with many options. We are even including 2 round trip airline tickets, okay? So looking at your account here, I'm sorry?
I was saying, you said the first one was in Las Vegas?
Yeah, Las Vegas. You're correct.
Is there
And that's where...
Is there anything like just outside of Nevada that I could stay and said, I've got a warrant in Las Vegas currently that I haven't cleared up?
Oh, yeah. Don't you worry about that, because I would like to tell you also that this travel package is fully customizable. So I will give it to my promotional director, who will be the one to help you customizing your package, okay?
Okay.
All right. Well, actually, Dwayne, we're running a live promotion here today, and just give me one moment to find out what those promotions are, okay?
Okay.
I need you to stay in your line for one moment. Just stay in with me.
Okay. Need to turn that down. Hello? Are you there?
Yeah. I'm still with you.
There's music or something. I can barely hear you.
Yeah. That's a hold tone. All right? Just don't mind it. And just don't
Can you call back when there's no music? I can't hear what you're saying.
All right, sure.
Hello?
I'll call you back.
Hello?
Yeah, can you hear me?
Oh, I can hear you now.
Okay, so I need you to stay in your line for one moment again. I will try to transfer you again to my promotional director, okay?
Can you turn down your radio? The music's very loud in the background.
Oh, I'm so sorry, that's a hold tone. But I'll call you back.
Okay, thank you. That is why you don't talk. We were on hold, but she could hear us. She was still there. She was still there. Okay, she's going to call me back. Okay, so last time we got 5-day, 4-night vacations with 45 destinations. She said we only got Vegas this time. She's calling back. She's calling back. Here it is. Hello?
Yeah.
Oh, hello. Oh, the music's
me?
on. Thank you. I can hear you now. Thank
All
you.
right. Well, I can tell you that the music is a hold tone, and don't you worry about that. Just don't mind it, and don't hang up until someone speaks up, okay?
Could you just tell me more about it yourself?
Well, actually, my only job here is to give you the basic details or the information about your travel package. But to assist you further, I have here my promotional director, so I just need to stay on the line, okay?
Yeah. You must love your job. This is really cool. It's a lot of vacations. No, she hung up on me. That was too much. Oh. Man, we're never going to get to Vegas at this rate. All right. Well, she called back. She said she put me on hold, but she could hear me. I was suspicious because I heard just a little bit of noise in the background. And by saying hello, it sucked her in. It sucked her in. She was too eager to keep me on the line. That's important to know, because usually when you get put on hold, I think it's fair that I can tell you something and say, hey, here's what I'm thinking. Now I can't do that. We just have to telepathically connect. But I should have just shut up. Maybe she'll call back. All right. Ashley. We're Pickles, not politics, so we probably can't go to the House hearing right now. But yes, there is a live House Oversight and Accountability Subcommittee holding a hearing on UFOs titled Unidentified Anomalous Phenomena. Which is UAP, Exposing the Truth. Yeah, not going to happen. All right. Let's see. A friend of ours worked at tech support call center for a large digital editing software company and sent us audio recordings of the hilarious freakouts people had on hold often. Oh, yes. Hold is not what you think it is. Some people, they can still hear you. I thought she was cool with me saying that I had a warrant in Las Vegas. Anyway, we're gonna get ready. We're gonna go to lunch. I think we're gonna come back. We've got a little bit more court hopping. We'll watch possibly for some documents in some of the cases that we are watching. I'll do a little search for those. If you guys see any in, I don't know, say. I'm probably not going to read more Maya documents until something big happens there. But if you hear something in Brian Koberger's case, Corey Richins, I don't know, I guess Sarah Boone still has some stuff going on. At any of those big ones that we're following, or you know, the Jose Ibarra case as well, shoot a text to me on the burner phone. I'll see if we can read some of those this afternoon and stay up to date on those cases as well. Probably need to check the schedule and see what's happening as well. WhatsApp broke for me. Used to have WhatsApp, now it's broken. All right. That being said, let's go ahead and go to break. I'm really excited because I cooked some beef strips, like I seasoned them beautifully. I used some of that the flat iron red pepper, or not red pepper, but the flat iron red and black pepper flavors on it. Cooked them up, and it's I ate my fill, and then I put the rest in the fridge. I want to eat the leftovers today. I'm thinking it would go good on a salad. It's like little bites of beef, little tiny fillet strip, cooked, seasoned for perfection. Yeah, I'm excited, and I'm also a little bit hungry. So it's good. It's good. I'm a good cook. I can cook some things well, and this is one of them. It's also delicious if you add it to a beef stroganoff. Oh my goodness, that is good stuff. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till I'm done eating. And we're back live this afternoon for a little more court hopping as we prepare for a new trial, which is going to start Friday morning. Hope you're enjoying your hump day. I know I am. We'll see you on the flip side. It's going to be about an hour, possibly an hour and a half, because I'm going to run to the post office. I have to pick something up, and I need to send something. To Ian Runkle, and he's getting me the addresses for those people who bid on some items that I was selling. He's getting me those addresses so I can ship those out as well. So I've got a few things to do. Just about dropped my pen, but we're going to have lunch, get some stuff done, and we'll be back. My hump day hasn't had enough hump. The hump to hump. You need more humps. All right. Is that a dromedary or a camel that has more humps? I never know. All right, we'll see you guys on the flip side. Have a good one. Bye-bye.